Good morning, everybody. Welcome to the Courtroom Files Live. It's a Tuesday. Michael Groff filling in for Dan Soul all the rest of this week. We got a lot of stuff coming up. A lot of courts are very active this morning, so lots of places we can go. But after the kind of heavy day we had yesterday, let's start out in Michigan. Let's see what Judge Simpson is up to this morning. I imagine bond will continue, or maybe it's civil cases. Let's find out. Good morning, everybody.
It's changing around in here. I will call them all as one. Arbor One West versus Rico McGuire.
Morning, Your Honor. Alice Friedman on behalf of plaintiffs.
Morning, Your Honor. Deputy Gordon Layman, plaintiffs.
Okay, hold on a second. Counsel, I'm having an issue hearing you. Try again.
Good morning.
Yes. Okay. I'm hearing you. It's not you. I think it's the speakers in here are muffled.
Okay.
I turned it up a little bit.
No, it's okay. This courtroom. I want to be home. Anyway. All right, Mr. Ernie. All right. Okay. What are we doing, folks?
Well, at this point in time, the case is still in mediation in circuit and federal courts. And there's no real reason for us to do anything here today.
Got it.
And some of the buildings units have been certified, several, I think 40 some odd units have been certified for compliance. Certificates of compliance have been issued. But as far as any resolutions here today, I think we're just probably need another status conference. Is that fair? Is that fair, Debony?
Yes, I would say that's fair. I think at this point, there are maybe 35 individuals on the docket here. And
yes,
we can confirm that at least 90% of those are no longer on city side. They've moved, they're gone. So to the extent that that impacts the court's disposition on any of these matters, majority of these residents are no longer at Arbor One city side. They've moved on their own. They've been relocated. A lot of these issues are no longer issues when it comes to them being physically at the property.
got it. And okay. Mr. Henry.
That's accurate as far as we know, Your Honor. We have mediation set for November and December.
So in December?
In December.
All right, then from my standpoint, I'm going to then adjourn these sometime into the new year. It seems to me that's probably the best thing to happen. One of the issues that we do have, I think we still have monies for some of these individuals in escrow. And at some point, there has to be some disposition of that, whether or not it go to the landlord or whether or not it go to the tenant. But we haven't heard claims from tenants regarding that escrow. There are some that have come along pursuant to the circuit court order and have asked that for disposition on the escrow, and that's not a problem, but there's still monies that are just sitting there. So.
Your Honor, are you able to confirm how much that is again at this point?
I am not, but my wonderful staff is. Hang on.
There's $20,846 in escrow.
That was the number I was going to say. What was that number again?
$20,846.
Okay. And those are, and so that you know, those are on various cases and tenants. So maybe what I'll do is we have that list, right, as to what unit they're on. So what we'll do is we'll send that to council so that you guys have them, so that if you guys have, Mr. Henry, connections with those folks, they can figure it out, or the landlord can make their claim or do what they wish to do on that. All right. All right.
Your Honor, I'd like to make an oral motion to withdraw from any further representation of either of these plaintiffs. They've indicated that they don't need my services any longer, and I'm happy to relinquish my representation to Devaney. She's a wonderful lawyer, and they don't need me anymore, and I'd like to withdraw.
Henry, you have any objection?
No objection, Your Honor.
You have any objection to that, counsel?
No objection.
I thought she was going to object. She seemed to like you, Freeman.
No objection.
We get along very well.
We do get along very well. So,
All right. What I will do is I'll grant
Thank you.
that motion to withdraw. If you would, whatever format you'd like to do that in, if you would submit orders to us so that,
In the immortal words of Cleavon Little, Blazing Saddles. Excuse me while I whip this up.
Wow. I'm gonna leave that alone. Okay, then I will sign off on those orders. And then in January, let me give you a date here for everybody. What, Mr. Freeman?
Your 60 days would be January 6th,
Let's go to the next one.
January 20th.
January 20th,
Thank you, Your Honor.
2026, 9 a.m. All right. Okay. Thank you, folks.
thank you, Your Honor.
This is.
All right, we already got a Blazing Saddles reference to start the day in Judge Simpson's court. That was unexpected. I don't even have words. All right, well, they're doing landlord-tenant civil stuff. I told you, we just sort of dip our toe in after the kind of heavy day we had yesterday. So let's go over to Judge Dad and see what's going on in Judge McNally's court this morning. Good morning, everybody. Wow, we're already starting out with the audio issue. Excellent. If you had that on a bingo card, like what? We're 10 minutes in, maybe. All right. All right.
Yep.
There we go.
People against Jacek Frederick Terrace, 25D 237017 A and B. Mr. Rodriguez, have it. He doesn't speak English. Lisa, okay. Your name? You're charged with ORV trespass and no helmet or eye protection, which is a civil infraction. You have the right to an attorney. If you would like one, I will give you one. All right, it is alleged that on September 30 of 25 at 1 p.m. that you did operate a ORV and trespassed without consent on Granger near Veronica and Brownstown. That is a misdemeanor, punishable by up to $500 in fines, 90 days jail costs, or all of those penalties. Do you understand that, sir? You also have a civil infraction charge and no helmet or eye protection on an ORV. You understand that?
That's right.
Did you sign this advice of rights? Did you read it and understand it? If you plead guilty, you will be giving up all those rights and there will not be a hearing or a trial. Do you understand that? All right. You still wish to waive your right to a lawyer? I'll enter a not guilty plea. I'm going to give you a $500 personal bond. I'm going to let you go talk to the prosecutor. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed when you come back in without the gun. Okay? All right? You'll go meet with the prosecutor, see what you can work out. Thank you.
Barbara, thank you for the $10 super chat and for the gifted membership. The super chats and super stickers help me while Dan is out. Of course, the channel memberships, they help the channel. That helps Dan. That helps everybody. Thank you, Wahoo, for the $2 super chat. Really do appreciate that. And all of your support, all of you guys in the chat. This is the greatest community in law. Back to Judge McNally.
Arraignment and pretrial. I know you don't understand me. Lisa, can you convey this to him and we'll set a new arraignment and pretrial date? You can give him a notice and we'll get a Spanish interpreter.
Yeah, send him down. We'll use the app to tell him.
Okay. Go down the hall, all the way down the hall. Okay?
Thank you.
Cashier. Thank you. And then you
Judge,
just set it
what
down.
was his last name?
It's Melgar Rodriguez. Rodrigez. Perlin is the first name.
Okay.
Nagy Muhammad Ali Hafiz. 25M608-489A and B. Good morning, sir. Your name?
My name is Nagy Hafiz, Nagy Muhammad Ali Hafiz.
Good morning. You have a charge here of window tint violation, which is a civil infraction. Hang on.
Okay.
And you also have a charge of not having a valid license on your person. You have the right to an attorney. If you would like an attorney, I will give you one. Would you like an attorney?
No, it's okay, but the car is now what?
No.
Okay,
Right now,
No.
I have to just arraign you.
don't worry, no,
You don't want a lawyer?
no,
Are you sure? I'm just asking.
no.
Okay. I'm going to arraign you. I'm going to explain the charge, possible penalties, and your rights. And then you're going to go over and you're going to talk to the or the prosecutor.
Thank you.
It is alleged that on October 9 of 25 at 12:30 p.m. that you were operating a motor vehicle on southbound on I-75 near West Road in Woodhaven. They think you did not have a valid license on your person. That is a misdemeanor. It is punishable by, actually, they think you didn't have a license at all. No, operating without a valid license. That is a misdemeanor punishable by up to $100 in fines, 90 days jail, costs for all of those. You also have a second charge here of window tint, as I said. Do you understand that?
Yeah, I understand.
Did you sign this advice of rights? This document, did you sign it?
Yeah, yes, I,
Did you read it?
I read it, yeah,
I'm sorry?
yes, I read.
Did you understand it or do you want me to cover it with you?
No, I'm good, it's okay.
If you plead guilty at any time, you're going to be giving up all of those rights and we're not going to have a trial. Do you understand that?
I'm understand, but
So-
some of them I understand exactly, but I know. I'm good, don't worry about
Oh, I want to worry about it though.
it.
You understand? I want to make sure you understand all your rights. Listen to me. You have the right to a trial. At a trial, you can remain silent or you can testify. You can question their witnesses. You can bring in your own witnesses. We'll issue an order compelling any witness to appear here. And they will have to appear if you want to bring in your own witnesses. You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. If you plead guilty, you're giving up all of those rights and we will not have a trial. Do you understand that?
Yes, I understand.
All right. Do you still wish to waive your right to a lawyer?
No,
You want a lawyer?
no, I wanna pay, don't worry, I pay.
Wait a minute. Do you want an attorney, a lawyer to represent you?
No,
I'm going to enter a not guilty plea. I'm going to give you a $500 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. Do you understand that? Yes?
what, you give me $500 more? I'm not,
It's a personal bond. You don't have to post any money. Do you understand that?
yeah,
So I'm entering a not guilty plea. I'm going to let you go talk to the prosecutor
yeah,
and see if you can work something out with the prosecutor, okay?
okay.
Any questions?
No.
All right, good luck. Absolute quality lawn sprinklers. Call in the prosecutor, John. Good morning, Ms. Beard. How are you?
Good, Your Honor. How are you?
Nice to see you. It's been a long time. You doing all right?
I'm doing great. Thank you for asking. Hope you're
So
doing
you're going to plead responsible. You're representing Absolute Lawn Sprinklers. Your name?
Good morning, Your Honor. Mohammed on behalf of people.
This is not the end of the world, but I want you to know something, and I need to put this on the record. This defendant does work at the court and for me personally. I mean, they blow out my sprinkler system. You've already got an agreement here that says that the defendant's going to plead to overweight with the understanding that the violation will result in fines and costs being reduced to $1,375. Any problem with me handling it?
No problem, Your Honor.
Any problem, Ms. Beard?
No problem, Your Honor.
I just wanted to make sure. Okay, I mean, it's pretty elementary. If there was discretion, it might be different, okay?
Yes.
Agreed.
Judge, this is a civil infraction, correct?
Correct.
Understood.
Yes.
Yeah, I'll look at the court's discretion.
Well, I just want you to know, I wasn't worried about you deferring to my discretion. I was worried about you knowing that I hire them personally and they do work at the court.
Yes, no problem.
But you guys already agreed on fines and costs of $1,375, and I'm not going to deviate from that. Okay? Fair enough. To the charge overweight, Ms. Beard, responsible or not responsible?
Responsible, Your Honor.
And you're authorized to enter this plea on their behalf?
100%.
All right. I'll accept the plea 1375, balance due by December the 4th. Okay?
Thank you very much.
Have a good day. Happy Thanksgiving if I don't see you.
Yes,
Is this
same
a-
to you. Thank
Is
you.
this Issa Alloway here? Are you here?
I'm guilty of being overweight as well. Welcome, everybody. The Courtroom Files Live. It is a Tuesday. Thank you so much for hanging out. The 4th of November. The year has flown by. We're hanging out with Judge McNally for a few more minutes. There's some more courts coming online. I'm monitoring about, I don't know, a couple of dozen anyway, about 20, 24, 25 courtrooms. So we'll let you know how that works out. For now, we'll hang with Judge McNally for a few more minutes.
Hello, can you hear me?
I need your name, sir.
Yes, Your Honor. Issa Alloway?
Where's your lawyer at? Is he with you?
Yeah. He's
Well, I
up-
need him.
one
Where is
sec-
he?
Hey, John.
Mr. Lamphere, your name.
Chris Lamphere.
Sir, your name.
Pietro Battalion.
Your name again.
Good morning, Your Honor. Mohammed on behalf of people.
I got everybody here. Where's your lawyer?
He said he's in the waiting room.
Okay, you got to bring him out of the waiting room. I adjourned this sentence from October 21. Let me just wait until he gets in here.
Judge, he's not on Zoom.
I don't know.
I'm sorry, sir. Your name again, sir? Sir,
Yes,
your name again?
Pietro Battalion.
Okay, I just wasn't sure which other one you were.
He's out there now. I brought him in.
Counsel, I need you in here, please. There you go. Your appearance?
Abdullah Mugni, P number 85374 on behalf of Issa Alloway.
All right, I have Mr. Vitale as the victim. I have Mr. Lamphere as the victim. Another victim signed his letter by the name of signed his name to the restitution letter by the name of Mark Gardner. You guys said it looks like there was an agreement of restitution for $1,000. The victims here are asking for all kinds of money. They got $6,250 plus disposal of $300. That makes $6,550. They got economic loss of $1,980 plus $220 per month until restitution paid. They're claiming economic loss.
Yes, so Your Honor, since the last hearing, I had the opportunity to speak with the prosecutor on the co-defendant case, which is in juvenile court. And my understanding is full restitution has been paid in regards to the $6,250. The remaining balance of the $300 for removal of the items from the location, that's still remaining. I've spoken with defense counsel and we are now stipulating my understanding of $300. So restitution has to be only out-of-pocket expenses sustained by the victim. anything more we can't do. I've explained it to the complaining witness that economic losses is not something that we can receive as part of a criminal case, only out-of-pocket expenses. And since 6250 has been completed in the co-defendant case, the only remaining balance is the 300. I understand that defense had paid last time an amount of $1,000. We were just requesting that $1,000 be amended to $300 so that the victim or complaining witness can now be made whole.
Do you understand and agree to that, you and your client, Mr. Mugni?
That is correct, Your Honor.
I pronounced that correctly, right?
You nailed it.
Good. You understand that, Mr. Alloway?
Yes, sir.
You agree to that?
Yes, Your Honor.
Okay, we got a little problem with the recording. Just bear with me 1 second.
The only one to get right now, with you in the recording stopped, it was being still recording. So I stopped it. And then I did something that stopped the recording, so just want to make sure this was recording. Testing 1, 2, 3. Oh, maybe you're good. I turned it off and turned it off. Thank you. All right, Josh, let's try again.
Okay, is that working so far? All right, so we're still on record here. I want to make sure that the prosecution has explained that to you, Mr. Vitale.
Yes, babe.
Do you agree to that?
Yes.
Mr. Lampier, do you agree to that?
Yes.
So you understand, first of all, I want to make sure, did the three of you receive the 6250 that was paid on the other case?
We
It has not been received yet, but
Hang on, wait.
I'm sorry.
Only one at a time. Who wants to speak?
we'll let Pete.
Go ahead.
We haven't physically received it yet, but we understand from the juvenile court that it is on the way.
Okay, so they've received it.
Yes.
So you're agreeing to the restitution here in the amount of $300. Is that correct?
Correct.
Who are we going to make that? And you agree to that too, Mr. Lampier, true?
Correct.
Who is going to be the recipient of the check? Are we going to send it to all three of you? I would suggest we send it to you, Mr. Vitale, you, Mr. Lampier, and Mr. Gardner. Any problem with that, Mr. Lampier?
No problem with that.
Problem with that?
No.
And Mr. Gardner, just to be clear, is not here, correct?
He said he's in the waiting room, but hasn't been let in, but I'm not sure. He has technical challenges, so I'm not sure he's in the right waiting room.
See him out there, Lisa?
I'm sorry, who was it?
Mr. Mark Gardner?
Oh, yep, I messaged him to see who he was and he didn't respond.
Okay, bring him in too,
I'll bring
please.
him in.
So let's just take our time here, and then the victims can say something.
It's TCF Live. It is Tuesday. Thank you, Mama Joan, Grandma TCF, for the $10 super chat and for all of your support.
Mr. Gardner, can
Really
you
do
please
appreciate
turn
it.
your camera on for me, sir? You have to turn your camera on from bottom left-hand corner of the screen. There you go. Tell me your name, please.
Mark Gardner.
So I want to make sure that everything I just heard, you weren't in here. I didn't think you were here. Next time when you come to court, if you ever do on Zoom again, you have to have your name by your device or underneath your picture there, for the reason that we have to know who you are. We don't know that Motorola is Mark Gardner. But at any rate, I was just told that on another case related in juvenile court, that $6,250 was paid to the juvenile court, and that you and Mr. Lampier and Mr. Vitale are going to be the recipient of that. And everybody seems to agree, and I want to make sure you do, and if you don't, tell me, that the restitution now on this case, instead of $1,000, will be $300. Do you understand that? And do you agree to that?
Yes, Your Honor.
All right. Now, I'm going to let you guys speak if you would like. I'm going to ask Mr. Mugni, have you had a chance to review the pre-sentence report, and are there any material additions, corrections, or deletions?
I reviewed it with my client, Your Honor. There are no needs for corrections or additions.
Right? Anything that you would like to say on his behalf?
Yes, Your Honor. So I've gotten the opportunity to get to know Issa over the last month or so, and he's a good kid. He's a God-fearing, respectful young man who comes from a very good family. He has strong ties. His father has come with him to every meeting in my office. His father has shown up to every court date. Even now, his father is waiting for him in the office, waking up at, bringing him to our court at 8:30 a.m. for the numerous times that we've been here. My client, he's not a bad guy. He's a good kid in a bad situation who made a mistake trying to impress some not so good friends. And that's how we ended up here. My client was born with a birth defect, a disability called Stuve-Weidman syndrome, which causes him to have deformities in his bones. This has put him in a situation where he wants to fit in with whoever, with his friends. He wants to fit in with his friends, which led him to do these wrong acts, which he is sorry for. He feels awful about. He wants to get on the right path. This was a one-off mistake. He was given a good deal, which allows him to clean this off his record and start from scratch if he does everything correctly. He greatly apologizes to the owners of this facility. I know you're all here, and I want to take this second to apologize to you all for my client's and his friend's actions. This was a one-off mistake. It's not his character. It's not something that he does. He was in the wrong, and he fully admits to being sorry for what he did. So we
How long
apologize.
how long was he in jail on this?
3 days, Your Honor. Or no, sorry, one night. My apologies.
One night.
Yep.
All right. I'm sorry, I cut you off. My apologies. Anything else?
Yes. So I know that brother counsel, the prosecutor Muhammad, he ended up saying that we paid $1,000 last time. That was supposed to be held as bond just so my client wouldn't have to come back. He did pay that in full. So with the $300 that is going to go back in restitution, we ask that the remaining $700 be applied to any costs and fines. If your costs and fines are going to be over $700 in excess, my client is indigent. He's asking that he be given extra community service if you believe that the money needs to go above it, as he just has no more money to pay.
Thank you. Anything you would like to say, Mr. Alloway?
No, he said it all for me.
Be a leader, not a follower, Mr. Alloway.
I'm sorry about all this. Like,
I understand. Well, we make mistakes, and this was not a little one. It was a bigger one. Let's make sure you don't make any more. Be a leader, not a follower. You could have been saying we shouldn't be doing this, breaking into storage units and everything else that goes along with it. So really, use your head going forward. Mr. Vitale, would you like to say anything?
No, I'm just glad that it's behind us now.
Mr. Lamphere, would you like to say anything?
I do appreciate the apology. Issa, watching the event happen, you seem to be the leader in it. So even if you were trying to impress your friends, impress them with good rather than bad. And it sounds like that's the path you're on, and I'm happy to hear that.
Thank you. Mr. Gardner, anything you would like to say?
No, Your Honor.
Anything, Mr. Muhammad?
No, thank you.
12 months probation. I'll be happy to take it under HIDA. That was the agreement. You cannot leave the state without the consent of the court or violate a law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. You would attend the impulsive behavior program through Class A Training Center. Attend that, complete that. Probation will explain that to you. You're also to not have any contact with Mark Gardner, Pietro Vitale, or Chris Lamphere. You're not to enter or go near 24400 West Jefferson in the city of Gibraltar, County of Wayne. You're to serve 5 days jail credit, 1 serve 4. I'll let you serve those as follows. 3 days on the court work program. There's a $35 a day charge for that for a total of $105, and 1 day of community service. So 5 days jail, but I'll let you do 3 days court work, 1 day community service. That's at any nonprofit organization of your choosing. You have until December 20 to complete your community service. They'll schedule you on the court work program. In terms of in the check, we're going to make sure, Lisa, if you can make a note, the check, I'm ordering $300 in restitution. That's to be made payable jointly to Mr. Vitale, Mr. Lampier, and Mark Gardner. $200 in fines, $200 costs, $75 victims' rights fee, $50 justice assessment. That's 5 1/4. Screening fee $60 for $585. Probation fees are $240 for a total of $825, plus the court work program fees. Everything included amounts to $930. Now, I don't mind giving him time to pay. I believe I said $1,000 cash bond. So
Judge.
that should cover everything except $230 of restitution, counsel. So I'm just going to give him time to pay that. I'll give him until, can he? What, just tell me, I know you said he's indigent, but when can he just pay that by? Why is he not working, counsel, by the way?
I think he gets paid through the state for disability.
Okay. Lisa, the bond's in his name, right? Yes. Can you pay this anytime, Mr. Alloway? Can you go to somebody and get $230 and we'll be done with it?
Oh, yeah, I can.
Can you pay this by November the 10th? That's next week.
Yeah.
So you'll have to pay another 200. So I'm just going to indicate you're going to pay 1,000 now. And then the balance by November the 11th, which will be $230, because including the restitution, it comes out to $1,230. Okay. You're going to meet with probation counsel. Will you call 671-0201 extension 245? See when they can come in and get him, or when he can, when it's best for him to come in. And I want a review hearing date as well, Lisa, please, in a year. And you come back then. If there's no problems, this case is going to be dismissed if you've complied.
Yes, Your Honor.
October 20th of 26 at 9 o'clock.
So October 20th of 26 at 9.
Yes, Your Honor.
The court is closed on the 11th, so you just might want to let him know he has to.
Oh, yeah. Thank you.
Veterans Day.
Court is closed on the 11th, so I'll just give you till the 12th. You can't bring it in on the 11th. We won't be open, okay? But you could pay online on that day if you wanted. So
All right.
I'll give you till the 12th, Wednesday. So call that with area 734, Mr. Mugni, and they'll tell you when he can come in. Anything, any questions, Mr. Vitale, Mr. Lampier,
No questions.
Mr. Gardner,
No questions.
Mr. Mugni?
Yes, just to make sure I got the number correct. That's 734-671-0201.
Extension 245. So as soon as that comes out, you can say, just punch in 245 and just ask them when they want them to come over. Okay? Good luck. You should have your money soon, whatever's left, but we're going to probably wait till we get all of it, okay?
Thank you, Your Honor.
Have a great day. Thanks, you gentlemen. Have a good day. Thank you very much. Good luck,
Thank you.
sir.
Thank you.
Derek, Robert.
All right, let me make sure I understand the defense correctly from that defendant. Since he has deformity in his bones, I guess it's okay, or it sort of, minimizes what he did. So I'm legally blind. So I guess as long as I'm wearing my shades, my glasses, my blind glasses that I don't really normally wear on camera, but hey, as long as I wear these, I can screw up and do anything, and you can't say anything about it. Otherwise, you're evil. You're wrong. Interesting defense. All right. Let's, we haven't headed out. We haven't gone to Judge, we haven't gone out there to Judge West. She's been on hiatus for about a week and a half or so. So let's see what's happening in Texas with Judge West. I'll keep my glasses on, so if I screw up, I've got a shield.
This is 16-26460, and Mr. Cooley is on probation for obstruction or retaliation. And Mr. Macon has asked for a bond to be set. Let me look real quick here. I say real quick. Sorry, it's just taking a little bit. It's spinning. All right, so it's a straight probation. It was a 10-year probation that was probated for 10 years. And the allegations in that motion are an allegation of a new offense of tampering with or fabricating physical evidence from August 9th. And then failure to report by mail some dates, failure to report change of address, failing to report that arrest, possessing methamphetamine August 9th of 2025, failing to provide verification of performing community service, being somewhere other than at his residence at 12:12 a.m. on August 9th of 2025, and then just a little bit behind in court assessed fees. Let me see here. Looks like Mr. Cooley has previously been to Safe P as a condition of probation back in 2023. This is at least so he was on a deferred probation, revoked off of that probation, placed on a straight probation. So this is at least the third, it looks like, motion to revoke. Is that correct? Okay. I'm trying to get back all the way if I can find the old pre-sentence report just to refresh, but I don't see that.
I have a copy if you look at it.
I would love to look at a copy if you have it, that'd be great. And while you're doing that, what is the status of the new alleged offense of that tampering?
It has not been filed, Sean. It hasn't been filed yet.
Any idea of what's?
Probably will, but I can confirm that.
I can't hear you.
I expect it would probably be filed, but I need to confirm with you.
Mr. Macon, you may proceed.
Yes, Your Honor. I'd call Mr. Cooley, Your Honor.
Mr. Cooley, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir.
Mr. Cooley, your probation was transferred to Dallas, correct? Yes, sir. And have you, how many times have you reported in Dallas?
I'm not sure the exact number, but since I've been home for safety, I've been home for safety maybe 2 years ago. So
Monthly?
Monthly.
Okay. And during that time, did they give you your drug screening, drug test?
Yes, sir.
And did you pass all of them?
All of them.
Okay. Now, the judge has mentioned this new arrest and all. Were you in a car with other people?
Yes, sir.
Did you know they had paraphernalia and drugs in the car?
I did.
You did?
I did.
Okay, you understand you can't even be around people like that.
So I didn't realize that they had it to the last minute. It was like straight up like
Okay. But you weren't doing drugs?
No.
Okay. Why didn't you mail reporting things to Jefferson County?
So coming from Jefferson County and then being transferred to Dallas, it worked. coming home from St. Pete, there's a lot of different, let's just say a lot of different things that you're trying to keep up with. Every month when I meet the PO, they go down a list of things. Are you paying your fines? Are you keeping up with community service? Are you doing this? Are you doing that? Are you doing that? That wasn't on the list of things to do.
And you didn't think you needed to mail something?
No. Not at all.
Okay, but you reported all the time to Dallas?
I didn't miss anything.
And did everything you were supposed to in Dallas?
Correct.
Okay, who was your Dallas probation officer?
So I've had numerous. They switch them. I probably had, since I've been home from St. Pete, I probably had 3 or 4 different probation officers.
Okay. Now, should the judge grant you a bond, will you report and be here for every court appearance?
100%.
Okay, while we're on that, you turned yourself in, correct, as soon as you found out there was a warrant for your arrest?
I did. So I'm, Ms. West, and in all honesty, Judge West, I'm thankful for you. I'm truly thankful for you. That safety, it completely saved my life.
Okay. Now, should you make bond, you have jobs waiting for you, right?
I do.
Okay, in fact, you have 2 jobs.
Yes, sir.
Okay, so you're always staying busy and paying everything.
I am.
Okay. Your wife lives up in Dallas, and you would naturally ask that you be allowed to go back to Dallas, but report by mail to Jefferson County. You understand that now? Yes.
Yes, sir.
Okay.
Okay, so just for the record, I'm reviewing the administrative hearing, which has attached to it that incident report from the Dallas arrest. And I'm a little confused because the incident report narrative states that Mr. Cooley was the only occupant in the car.
May I?
Mhm.
So I was the only occupant in the car at the time. I was sitting at a hotel. I had 3 to 4 people with me. They ran upstairs to the hotel to come back down. So they were literally.
So what?
I offered the officer.
Hold on.
Yes, ma'am.
Okay, and that's fine if you were doing that. It's after midnight, you're sitting in a car at a hotel. What are they doing running up and down other than getting drugs? Because you've got a meth pipe that you throw out as soon as the cops get there. And Mr. Smith, anything to add?
Well, not as far as that goes, Judge, but I was going to show you the pre-sentence update that shows that he was aware of reporting by mail because it was addressed in 2022 or 2023 when that came
up. Your request for a bond's denied. I mean, this has been probation since, well, I guess when did we actually start? Back in 16 or even before?
I was here, Rachel Grove was the prosecutor originally.
Yeah, and it's gone from the opportunity of a deferred to now a straight to safety to being out at midnight with buddies running up to a hotel with meth. So, nope. I'll set it for an announcement for the MTRP.
We'd like a hearing as soon as possible.
Do you want to go ahead and go through the motion today then? Because you'll have to go through and plead true or not true, and then if you want a hearing on punishment, we'll reset it for that. So if you want to go ahead and do the pleas today, y'all can visit real quick.
Could I have a week, Your Honor, to go with over my client and be ready for that?
Yeah, it'll just be for the pleas though, not a hearing.
Yeah.
Okay, unless it's, because we'll have to get an update and all of that. So we'll reset it. I don't know what next week looks like. We don't have next week because it's a holiday. Tuesday is, so it'll be a couple of weeks.
Oh, Thanksgiving.
No,
No,
next week is Veterans
Y'all
Day.
observe that too?
So it'll be at least 2 weeks, and that'll be just for a plea. I mean, just for the pleas. Okay, we'll reset it.
Yeah.
All right, you can go back with the bailiff.
Today, so.
Ashley, thank you for the $20 super sticker. Barbara, Mama Joan, Grandma TCF, thank you for everything that you guys have done. Wahoo. Hi, everybody. If I missed anybody in the chat, donating and helping us out, really do appreciate all of you guys. Thank you again so much for joining me this morning. TCF Live. It is a Tuesday. Hey, let's let's go to someplace we haven't gone since I've been hosting the show. And let's see what is happening in Judge Mert's court. We haven't been up here yet, again, since I've been hosting. So let's see what he's got going
they're
on.
at the Department of Corrections, sir. Can you tell me your name, please?
Yeah, Byron G. Goodman.
Mr. Goodman? Okay. We'll go on the record in People versus Goodman. This is file number 255099. The record should reflect Mr. Goodman's present today by video from Department of Corrections. I can have counsel put your appearances on.
Ryan Ziegler.
Thomas Seeger appearing with an on behalf of Mr. Goodman.
Thank you. Mr. Seeger, how did we want to proceed in this file this morning?
Your Honor, it's my understanding that Mr. Goodman wishes to tender a plea to one count of resisting and obstructing with no habitual offender notice.
Is that a correct statement of the offer, Mr. Ziegler?
It is, Your Honor.
Mr. Goodman, were you able to hear that?
Yeah, I'm making a plea agreement. You turn it up a little bit, that'll be all right.
Yep, we'll speak up for you. So, yeah, the plea agreement is that you would plead guilty to one count of resisting or obstructing a police officer. The second count of assault and battery would be dismissed along with the habitual offender enhancement. Is that your understanding
Your
of
Honor.
the plea agreement? Okay.
Yes, Your Honor.
Is that how you wanted? Is that how you wanted
Yes,
to
Your Honor.
proceed today? Okay.
Yes, Your
Can you
Honor.
raise your right hand? Can you raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Seeger, is this plea going to affect any kind of parole or probation status?
Arguably, Your Honor, it could be consecutive.
Okay. Because of a parole status?
Not because of his parole, because at the time he was on bond awaiting sentencing for a felony.
Okay.
Kate,
To your
running
knowledge,
concurrent?
Just one second, Mr. Goodman. To your knowledge, is he on any kind of probation or parole at this time?
He's not, Your Honor, he's lodged at the Department of Corrections and the court had sentenced him recently.
Okay. So, Mr. Goodman, the maximum possible penalty you could face for the charge of resisting or obstructing is up to 2 years and or a $2,000 fine. Do you understand that?
Yes, Your Honor.
Also, because you were on bond at the time of this offense, the court could, but does not have to sentence you to consecutive sentencing. Do you understand that?
Yes, Your Honor.
With all of that in mind, what is your plea to that charge today?
I want to plead guilty and possibly maybe get sentenced and just throw it to the into the 5 years, make it 2 years. You know, I got like 29 months to 5 already. And
Okay, all right.
if
Well,
it's all possible.
We'll talk about that in a second. But I want to go through your rights with you.
Yes, sir.
You have the right, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, Your Honor.
You understand that you're giving up and waiving those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here on the record today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty to this crime because you are actually guilty?
Yes, Your Honor.
The information I have indicates that this happened back on September 3rd of 2025. Is that the correct date?
September 3rd of 2025. Yes, Your Honor.
Okay. On that date, were you here in Kalkaska County?
Yes, Your Honor, at my place.
Did you come into contact with the deputy from Kalkaska County?
Yes, Your Honor.
Did you know that he was performing his duties as a police officer at that time?
Yes, Your Honor.
What did you do to resist or obstruct that police officer at that time?
He told me to give him my phone, and I didn't, so he snatched it out of my hand.
All right. And was he ordering you to give him your phone as part of an investigation that he was conducting at that time?
He just said I can't be on the phone while I was in the cop car, and he told me to give it up. That was it.
Okay. All right. Mr. Ziegler, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
Counselor, are both of you satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Mr. Goodman, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge of resisting or obstructing. The court will accept your guilty plea. We're going to set the sentencing hearing for a different date. In the meantime, somebody from the probation and parole is going to do an interview with you. And then you'll have an opportunity at that time to, we'll talk about that sentencing. It sounds like what you're requesting to have the sentences run together. Is that right?
Yes, Your Honor. See, I just had one of those pre-sentence investigations like 3 months ago for this other case. Is it necessary? You gotta do that? Can't you just like do it today, so I ain't gotta go all the way up there? Cause that's a long trip.
Well, yeah, we can do it by video. You don't have to, if you'd rather do it by video, we can do it by video.
Yes, Your Honor.
Okay, but I do need to have that report prepared for my information because this is a different circumstance and a different charge. And other than what we've said here today, I don't know anything about what happened, and I need to have some more information to be able to determine what an appropriate sentence is, okay?
Okay, but what's maximum be consecutive instead of concurrent? Is that what you're
Right,
saying?
consecutive is back to back, concurrent is at
Yeah.
the same time.
Yeah, yeah. All right, I
Okay,
just
so
thought
you'll be
maybe-
notified, we'll do that sentencing hearing by video like we're doing today, all right?
All right, I'm just trying to get on and get to a level here. I'm still stuck at RNGC. I hope this court stuff ain't holding me back from getting to a regular level.
Okay.
You know,
All right, thank you. That's all for this hearing today. The
all
court's
right,
gonna
thank you.
disconnect.
I don't think it's the court that's holding you back, sir, but that's just my opinion. TCF live on a Tuesday. Michael Groff filling in for Dan Soul all week. Thank you so much for joining me. Hang out in the chat, won't you? You can play bingo in there as well. And I suggest you say hello. It's a very friendly community, very welcoming. We'll hang out with Judge Mertz and see what else he's got going on before we head elsewhere.
And if you gave us one final jury status conference somewhere in advance of trial, that may be helpful, but at this time, he intends on proceeding to trial. Okay.
All right, Mr. Ziegler, how much time do the people need to be prepared to go forward with trial in this case?
I would say at least 60 days, Your Honor.
Okay, if we set this for 90 days, is that enough time?
Yes, Your Honor.
Mr. Seeger, is that enough time for you?
Agree, Your Honor.
And Mr. Ziegler, how many days of trial do you think we'll need?
I would say at least 3 days, Your Honor. I'm probably gonna have somewhere between 12 to 15 witnesses. Without doing more digging.
Okay, Mr. Seeger?
I think, yeah, 3 days is probably appropriate, yeah.
3 days. Okay, so we'll set this for a 3-day jury trial at about 90 days out. The court will set it for a final status conference on the motion day immediately prior to trial. And that will be the plea cutoff. So Mr. Griffith, to the extent that there are any new or different plea offers, or you wish to discuss that further with your attorney, that final status conference prior to your trial date would be the last date to enter into any kind of plea agreement. Mr. Ziegler, are the people anticipating any kind of motions?
At least I'll be filing a 404B notice, Your Honor. I don't anticipate any motions per se.
Okay, Mr. Seeger.
Yeah, I was still contemplating some potential motions, but they would probably most likely be motions in limine.
Okay, so any motions or objections to 404B notices would need to be filed and heard no later than the date of that final status conference. Mr. Ziegler, any other dates I can address for you for scheduling in this file?
No, Your Honor.
Mr. Seeger? No, sir. Mr. Griffith, do you have any questions about how we're going to proceed with your case?
No, Your Honor.
Okay, all right, thank you. That's all for this hearing today. You'll be provided, Mr. Griffith, with notices of the trial dates as well as the date of that final status conference. And the court's going to disconnect at this time. All right, People versus Darnell Ross.
Ready, Your Honor.
This is file number 255094. The record should reflect Mr. Ross is present here in the courtroom today. If I could have counsel put your appearances on in this case.
Thomas Seeger appearing with on behalf of Mr. Ross.
And Mr. Seeger, can you tell me the status of this file this morning?
Your Honor, an offer has been extended. However, at this time, Mr. Ross wishes to proceed to trial. So I just asked that the matter be set for trial and that he perhaps give us one final statement conference and ask that date.
Okay, Mr. Ross, is that correct?
Yes, sir.
Okay. And Mr. Ziegler, how much time do you need to be ready for trial in this matter?
I can be ready within the next 60 days, Your Honor.
Mr. Seeger?
That's fine, Your Honor.
Okay. And Mr. Ziegler, how many days of trial?
I think this would be a one-day trial, Your Honor.
Mr. Seeger?
Agree, Your Honor.
I think based on my schedule, it's probably going to be a 90-day duration interval. So the court's going to set this for a one-day jury trial at about 90 days. We will set this for a final status conference on the motion day immediately prior to trial. That'll be the motion cutoff. And Mr. Ross, there'll be one more hearing before your trial date. To the extent that you did want to consider any plea offers, that would be the last day to enter into a plea agreement, okay?
Yes, sir.
Mr. Ziegler, anything else we need to address for scheduling on behalf of the people?
Your Honor, would there be a motion cut off as well?
Correct.
No, Your Honor.
Mr. Seeger?
Nothing further, Your Honor.
Okay, so Mr. Ross, we'll send you notice of your trial date as well as that last status conference. It's important between now and then that you stay in touch with Mr. Seeger so that you can help him be ready to proceed to trial when that's scheduled, okay?
Yes, sir.
Do you have any questions about how we're going to proceed?
No, sir.
Okay, thank you. That's all for today.
I really hate it when the attorneys, they talk like this and they don't really emote or project. So it's very hard to hear over those microphones. The judge is talking nice and loudly, but the rest of them are not. Anyway, good morning, TCF Live. It's Tuesday. Michael Groff here. And let's head down to Texas. It looks as though Judge Stevens has got a contestant coming on down. So let's see what's happening over there this morning. It's always fun and frivolity in Judge Stevens'
Do you
court.
have a phone number for him?
I do, sir.
Oh, right.
Yes, sir.
Tell him we're all waiting for him.
Yes, sir. It's frustrating.
Yeah. You want to sit where I am. You don't know what frustration is. I believe it's.
I was pretty sure Judge had somebody coming on down. And, well, we'll see. This is what happens when you go to, hey, I'm wearing my glasses, so if I screw up, remember from that case before, if I screw up, you can't come after me because, disability, I'm therefore immune from any sort of persecution. All right, well, Judge Stevens awaits the next contestant to come on down. Why don't we check out, who are we going to check out? Let's check out Judge Boyd. It's our quest to give you 9 to 11% more Judge Boyd here, so let's
There's no application. Is
give you more Judge Boyd.
Right, thank you. Yes. Court is calling 2025 CR 011986 State versus Terry Talton. Can I have parties announced?
Robert Bromont for Terry Talton.
And are you Mr. Talton?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am, I did.
Court will find that the state is in compliance with discovery. Mr. Talton, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
Yes, ma'am.
Mr. Talton, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
He's mentally competent.
Mr. Talton, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering into this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 180 days in the Bexar County Jail under 1244. There's an $800 fine and no applications. Did you understand that to be the plea? Defense, is that the plea?
Yes, ma'am.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Good.
State, any evidence?
Yes, Your Honor. State author states exhibit 1 in all attachments.
No objection, Your
All
Honor.
right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am, please.
All right. All right, so in regards to this case, I know that the theft case is not a misdemeanor. I guess it's a municipal court case.
Yes, sir. But there's no pending theft here.
All right, okay, thank you. All right, is there anything you wish to say on behalf of your client?
I think you'll do well.
Then the court will find you guilty. The court will sentence you to $800 fine. Time and money will run concurrently. And the court will sentence you to 180 days in the Bear County Jail under 1244. Does he have adequate time or no?
Yes, 112 days.
112 days.
All right. So you'll receive credit for any time served. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. So here's the thing. It appears that you may have a drug problem. If you do not take care of that, what's going to end up happening is you're going to be in and out of jail, maybe prison, or either somebody's going to have to identify your body, because the last time you use may be the last time you use. The other thing, your attorney is telling me you have 112 days in. Usually people are like, well, why didn't she give me a judgment satisfied? Let me explain to you why I didn't say judgment satisfied on the record. I am not in charge of your receiving 2-for-1 or 3-for-1 at the jail. Normally, if you're in general population, which means you're not causing any problems, for every day you spend in custody, the sheriff will give you credit for 2 days. If you're a trustee, which means you do work at the jail, maybe clean, maybe laundry or whatever, then the sheriff, instead of paying you money, they'll give you credit for every day you serve, you'll get credit for 3 days. I'm not in charge of that. So if they say that you are causing problems at the jail, they can take away your 2-for-1.
Yes, ma'am.
So the only thing I'm in charge of is I just sentence you to 180 days. You have to serve 180 days. How the sheriff is calculating that, that's how they calculate that. So I can't say you have a judgment satisfied, because they're giving you credit for that, not me. You understand? All right, good luck to you.
That mean something, I'll have to do like 2 more months.
No, I'm not saying that. What I'm saying is I'm only giving you credit for the 112 days.
Okay.
If the sheriff is giving you credit for every 2 days that you're in, or every 3 days that you're in, they will probably release you. Now, mind you, I can send a letter to them and say, I want this person to serve every day and not get 2-for-1 or 3-for-1. I can do that. But what I cannot do is I can't force them to give you 3-for-1 or 2-for-1.
Yes.
That's completely up to them.
Yes, ma'am.
Okay? All right, good luck to you.
Thank you very much.
You're welcome.
Have a seat, sir.
Thank you, Judge. Judge, your prosecutor did a good job. She was prompt, had the documents ready. I
So,
mean, that's the way it should go.
oh, thank you so much. All right, who's here on Johnny Richard Gonzalez?
Mr. Gonzalez, for president, ready?
Okay. Let me just pull it up on the system.
Tilton?
All right. Court is calling 2025 CR 010295 State versus Johnny Richard Gonzalez. Can I have parties announced for the record?
Mr. Sullivan for I'm sorry, for Mr. Gonzalez. Sorry.
And are you Johnny Richard Gonzalez? All right, you entered a plea to count 1 and count 2. You entered a plea of guilty. The defense waived PSI and waived a TAP evaluation. According to the plea bargain agreement, the state was proceeding on counts 1 and 2. Punishment was to be assessed at a cap of 8 years in the prison. There's a $2,000 fine. The state is opposed to your application for deferred adjudication or community supervision. They're taking in consideration 2025 CR 013223. There's to be restitution of $180 to DPS. And there's to be restitution in AUS -2502-02545. State, do you have any witnesses?
Not that I'm aware of, Your Honor.
Defense, any witnesses?
No, Your Honor.
All right. Then state you are opposed.
From what I can see in front of me, I believe our opposition has to do with his criminal record. Going to hand it over to Dan.
All right, thank you. So if you'll announce for the record, please. All right, defense has informed me on this case. He has no witnesses. The state is opposed to the defendant's application. Do both parties need a couple of minutes?
Yes, Judge, I guess it's review. I was going to offer the criminal history.
Yes. Okay.
Or this time to get our first two point.
No objections are, I think, this all boils down to one conviction for drugs and one conviction in the police for file function. It's the problem. We have no objections to the.
Then the court will review the exhibit.
All right, well, Judge Boyd reviews that exhibit. Reminder that Tuesdays and Thursday nights, 8 p.m. East, 5 p.m. Pacific, we have a sidebar, although not this evening because of some scheduling issues, but we'll be back on Thursday night, 8 p.m. East, 5 p.m. Pacific for sidebar. Be sure to join us for that. A whole panel of folks, minus, of course, Dan, because he's still on vacation, on hiatus, well-deserved vacation. He'll be back on Monday, but then it looks like Tuesday, since it's a holiday, most of the courts will be out of commission. So I'm kind of thinking Dan's going to have another day off.
Any witnesses? Or
Slacking.
Just argument.
Just argument. Your Honor.
All right, you may proceed.
Yes, ma'am. As I look at his history, he's got an issue, and all of it seems to circle around drugs. The court did the thing I think that's helping him the most, regardless of the sentence today, and that was he needed treatment. And he got treatment, and he went to lifetime. I think it was 45 days there. And Your Honor, since that time, my understanding, the reason he was put back in jail was because he was having some issues with his bail bondsman. And the conclusion, and the only conclusion I can reach about him, it's an excellent one. And that is the fact that treatment so far took on him. And we would submit to the court based on that this court consider probation and all the things that this court can use to make sure he performs well. Or in the alternative, this is a cap, sentence him at the lower end of the cap. And once again, this is because from what I can tell, lifetime took. And I know he's got a lot more work to keep it working. He's going to have a day in day life where you fight drugs, and there's a program out for them. He needs to make a meeting every day for the next 90 days, regardless if he's in jail or out of jail. Thank you, Your Honor.
Your Honor, you're talking that you denied application since 8 years in prison. I think that the defendant's record is pretty clear that he had been given a chance previously for treatment, and not only does he keep possessing narcotics and controlled substances, but with felony convictions, he's also possessing firearms. And so as part of the plea deal, we did waive the habitual enhancement, and what was listed on the indictment is a 2017 conviction for possession with intent to deliver PG1 less than 1 gram, but in a drug-free zone. And then the second enhancement was for a 2020 felon in possession. And so I think there are programs to address drug issues, but there's no program to address somebody that just is committed to possessing firearms for that reason.
All right, thank you. Is there anything you wish to say?
Yes, ma'am.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Johnny Richard Gonzalez.
All right. What would you like to say?
I'd like to say that lifetime recovery helped me a lot because I didn't know how to deal with none of my past issues. I was self-medicating, and with lifetime recovery, I learned how to cope. I learned how to ground myself and process the situation, and now I know how to cope with it. And I would like to continue my life with the tools that I learned at lifetime.
All right, state any questions?
So, Mr. Gonzalez, back in 2024, when you picked this case up, and then you have the other case that was from 2025, you're aware of those 2 charges that you're here for today, correct? Okay. And so you would agree with me that the facts and circumstances of both of the cases are kind of similar, correct?
Yes.
And that you were operating a motor vehicle both times, is that correct?
Yes, ma'am.
And then both times you were asleep at the wheel, is that correct?
Yes.
And that's how the police officers make contact with you, correct?
Yes, ma'am.
Okay, and so in the 2024 case, you were also, well, I guess what was going on in your life that you were asleep at the wheel of a motor vehicle?
I was going on with family issues, and so I was self-medicating, and I was working as well. So I just didn't know how to cope with none of that stuff.
And when you say self-medicating, what were you using to do that?
I was using methamphetamines so I could still be able to work.
And then in the 2024 case, and that case, you were also in possession of a floodlight, is that correct? The motor vehicle?
Yes.
Okay. And when did you complete lifetime recovery? Was that a part of your bond?
It was part of a pretrial. Yes. And I don't remember the date I completed.
And was that inpatient or outpatient?
It was inpatient.
Okay. And do you recall how many days that was?
It was 45 days.
Okay. And then just regarding your history, you do have prior history of drugs and also possessing a firearm, correct?
Yes, ma'am.
And
Just one question. You understand for the rest of your life, especially for the first 2.5 years, you need to make a meeting every day sometimes more than one day.
Yes, sir.
That's the only way you know you can make it.
Sure.
Thank you. Pass Whitten, Sean.
All right, I have a few questions. Any objection?
No, no, no.
Okay, so gang affiliation, any?
No, ma'am.
All right, so you said you're going through things. What things were you going through that you continue to use?
I was going through my father had just passed recently, and so while he was sick, everybody was fighting over the property. And I was not, my brother does not let me stay there because I was self-medicating and stuff, but everyone's arguing over the property and stuff and just.
Which people do when there's no will.
Yeah.
That's why everybody should have one.
Mhm. And so when my father passed, my brother ended up making a will and put everything in his name. So I was in the streets, so I was just.
Well, that's sort of a crime, maybe. I don't know.
Yeah.
Somebody just can't make up a will after somebody passes and sign off on it.
So like, I was just.
But it's been to happen.
I was just trying to survive, but I didn't know how to cope with none of that stuff before. I didn't know how to ground myself and process it and use my brain. So, but I learned a lot when I was in Lifetime.
What did you learn at Lifetime?
I learned how to slow down and process the situation, and instead of taking off to the races, no, I ground myself and find coping skills as working out or the Bible and working, just staying busy and doing meetings and just speaking about my problems.
Mhm. Do you have any children?
Yes, ma'am.
What are their ages?
I have a 15-year-old, a 14-year-old, a 9-year-old, and a 5-year-old.
And have you been in their life at all
Yes, ma'am.
while you've been using?
Unfortunately, yes.
All right, any other questions?
No question, John.
All right, so here's the thing. I'm gonna give you a choice. Some people I can give choices. Some people I can't give choices. Some people will come before me and they'll say, hey, you just gave this guy a choice. Why can't I have a choice? And I'm like, because you're charged with murder, you know. So I'm going to give you a choice. Here is your choice. One, are you deserving a deferred adjudication? Absolutely not. But I will give you deferred adjudication. And what I can tell you about deferred adjudication, the state is asking that your punishment be capped at 8 years. If you are unsuccessful at deferred adjudication, you will be looking at the full range of punishment. That's 10 years, right? But I'm telling you, with deferred adjudication, you're going into inpatient treatment. You're either doing inpatient treatment or felony drug court. Felony drug court, they may or may not be able to accept you. We can see. But if felony drug court doesn't accept you, inpatient treatment, there's no coming back to me saying, Judge, it's taking too long for inpatient treatment, because that's where you would be going. Or this is your other option. I will find you guilty and I will sentence you to 5 years in the prison. Which do you prefer?
Inpatient.
All right. Then this is what the court will do. Counts 1 and count 2 will run concurrently. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. And state, I know you were opposed, but does anyone want to give their opinions on the length of a deferred adjudication?
I'll defer to the court.
I would defer to the court too. I think you're using your wisdom to decide where you're going. And I agree. If this guy needs to be in a place, from my life's perspective, that he has to live with this every day. In the words he's got to constantly see is go to a meeting, go to a meeting, go to a meeting. If you feel anything in your brain, any new thing or old thing, drag your butt to a meeting. That is one thing you can always simply do.
All right. So there is to be 8 years deferred adjudication, proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. That could potentially change. It's going to 100% depend on you, because you should not be around any children, unless your children, unless you are supervised in a controlled environment, until I deem that you are clean and sober. There's to be no residing in households with minors. There is to, Ms. Abrams, do we still need to do a TAP even though I'm saying that he is to do inpatient treatment?
Yes, Judge.
All right, there's to be a TAP evaluation in custody. Follow TAP after TAP in custody, I want inpatient treatment. So there'll be inpatient treatment. I want a referral to felony drug court in custody. And of course, Ms. Abrams, this felony drug court accepts him. I would prefer for him to be in that program. There should be field visits 1 time per month until further notice. There's a $2,000 fine that will be probated. 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, 20 hours will be deemed satisfied. The remaining 180 hours, for every sober meeting you do, 100 hours will be deducted from your community service hours. Take in consideration 2025 CR 013223. There's to be $180 restitution to DPS. State the cause number I guess this is AUS 2502.
Yes, Judge.
02545. Is that different from the DPS?
That's just a reference number for the GPS, like
Okay.
reference for the restitution.
All right. So there's $180 restitution to DPS with reference number AUS 2502 02545. Probation, is there anything else that's needed?
It's inpatient treatment you want.
He needs safety. Oh, I said 8 years deferred. Okay, thank you. Is there anything else?
Nothing else on my end, Judge.
Is there anything else you need from the court to be successful?
Thank you so much.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So here's the thing. You came in here thinking, hey, I'm probably going to go to prison. This is your chance to change your life. If you do not, what's going to end up happening is you're looking at 10 years in the prison on each of these counts. It'll run concurrently because it has to run concurrently, but that will be potentially 10 years away from your children if you mess up on that. And by the time you come out, some of your children will be adults, and some of your children may be calling somebody else father, right? And if you don't want that, you need to change your life, because the last time you use may be the last time you use. You understand? And you now know, if you didn't know before, you're not allowed to possess any weapons. I know that sometimes people are going to go get drugs from certain places they shouldn't be getting drugs for, so they need protection. You can't do that. You're not allowed to carry a weapon. You're a felon. You understand? Is there anything else that you need from the court so that you can be successful in this probation? All right. So here's the thing. From here on out, everything that you do, you need to ask yourself, could this potentially result in me going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. And if you don't want to do it for yourself, then do it for your children. You should always do it for yourself. But if you don't think you're worth it, ask yourself, are your children worth it? You understand? And that whole conflict you have with your relatives, when you use, sometimes relatives get tired. It's like, we've invested this, we can't trust them anymore. So you're gonna have to build up your reputation for trust and honesty with them again. You understand? All right, good luck to you. No,
All right, words to live by from Judge Boyd. That's why we love Judge Boyd. Sometimes may not always agree with her rulings, but we do respect a lot of what she has to say, that's for sure. And that's why we give you 9 to 11% more Judge Boyd here. It's TCF Live. It's Tuesday. It's Michael Groff filling in for Dan Soul. Thank you so much for joining me, everybody in the chat. If you're just watching, you're lurking out there, of course, that's cool too. If you're watching us at some other time other than Tuesday, the 4th of November, 2025, well, let me know how the future turns out. I'd really love to know. In the meantime, let us head to, do we dare? Well, all right. Let's do it. Let's head to Louisiana. It's the Louisiana Board of Pardons and Paroles. Looks like they've got something cooking over there. So let's see what they've got going on. Oh, yeah.
All right, the Committee on Parole is now convening at Union Parish Detention Center. It's 9:23 a.m. on Tuesday, November 4th, 2025. Could we get the officer there at Union Parish to please introduce yourself for the record, sir?
Yes, ma'am. My name is Sergeant Hill.
All right, thanks so much for accommodating us this morning, Sergeant Hill.
Yes,
And
ma'am.
we have before us Mr. Russell Doom. Is that you, sir?
Yes, ma'am.
Would you introduce yourself? Tell us your name and DOC number.
My name is Russell Wood Doom III, DOC number 771600, ma'am.
All right, thank you, sir. Mr. Doom, I want to acknowledge we have some guests here with us in Baton Rouge. We have the victim's mother, Ms. Jackie Jones, and she'll be saying a few words in just a few minutes.
Yes,
along,
ma'am.
The stepfather, Mr. Gilbert Dewey. Both are here in opposition, but first I'm going to read some identifying information into the record. And
Yes,
then
ma'am.
I'm going to ask you to confirm or verify that it's accurate. And then I'm going to turn it to Mr. Freeman, seated to my right, because your case has been assigned to him.
Yes, ma'am.
So, Mr. Doom, you are classified as a first felony offender, currently serving a 7-year sentence. You were sentenced in August of 2022 for sexual battery and computer-aided solicitation of a minor. Your parole eligibility date is March 18 of 2026. You don't earn good time, so your full term date is December 18, 2027. Is that
Yes,
accurate?
ma'am. Yes, ma'am.
Mr. Freeman?
Okay, Mr. Jones, good morning.
Good morning, sir.
First off, tell me, what did you do to get yourself put in there? And what have you done since you've been in there that you think that I should let you out today?
I had a bad night, sir. I was drinking. I was on drugs. I succumbed to problems that I've dealt with in my life, and my victim, Miss Kate, I apologize. I made a mistake, and I'm doing my time on that mistake. I don't look at it as I didn't make a mistake, and I don't look at it as I'm innocent. You know, I was convicted. I didn't fight the system. I took my charge and I took my sentence. And I was actually expecting to not have a parole date, sir. When I got my rap sheet, there wasn't I don't know if it updated with laws changing, but since I've been incarcerated, I've worked on myself. I'm currently the laundryman at the facility. I've worked basically since January 8th of 2022 as the laundryman at this facility. I've been in no infractions. I get along with the staff. I'm trying to fix myself because I've lost a lot of time with my son, some very valuable time. He's 15 currently. I should have been there. I lost my father when I was 6, and I know how not having a positive male role model in your life can affect you. I just want my victim and the family to know I'm sorry. I want to better myself. I want to be the father that my son deserves. I want to be the husband that my wife deserves. I want to be the citizen that the public deserves. You know, I know that I'm going to have stipulations, and I know there's things that I'm going to have to carry along in my life. If I do get out, whether it be on parole or my full-term date, it's going to be a struggle, but I know that I'll be able to achieve what I set my mind to. I just want to be the man that the people in my life deserve, the God-fearing man that doesn't want to make these mistakes. I don't want to drink anymore. I'm surrounded by bad things that I could get into here that I choose not to, because I don't want people to look at me as my faults. I want people to look at me as what I could be, not what my past reflects. I want to just, like I said, I want to be the person that has respect. I disrespected my name and my honor, and that's not anything my family or the people that love me deserve to have to deal with.
Gotcha.
And I know that it's going to be an ongoing battle, and I just, with God with me, and I just want to be able, like I said, to be the man that people respect and that my family deserves. You know, whether I get paroled or do my full term, you know, it's a day-to-day. Yes, sir.
Okay, I might ask some more questions. We're gonna get into it deeper during our. Okay, we have nobody here on your behalf, but we do have some victims here, and we have Miss Jackie Jones and Mr. Gilbert Dewey. Ms. Jones, you wish to speak? Would you please go to the podium and tell us what you want to know about us to know about Mr. Dewey?
So I told my daughter he was somebody she could trust. He defied that. That has caused a strain on my relationship with my daughter because he knew of things that had happened to her and he abused that. He's not a good person. He's not trustworthy to be around other children. This isn't the first time. It may be the first time he's been charged, but it's not the first time he's ever had issues with juveniles. I think he deserves the full time. I don't believe he's gonna be the model citizen when he gets out. He may be the model citizen while he's on parole. But once he gets off of parole, there's nobody to watch him anymore. There's plenty of people that have told me that they were too scared to go to the police, do their thing, you know, just. He's destroyed my family. My daughter, I haven't seen her or spoken to her in months. I don't know where she's at. I'm not saying everything he did was the cause of this, but he was the tipping point. And I don't have my little girl no more. He doesn't deserve to be out here.
Thank you, ma'am. Appreciate you coming today. Okay, Mr. Doom, let's get into you.
Sir, can I start by saying that I apologize for any harm to her. I would like to apologize to Jackie and the family. I'm sorry. You know, I know those are words, but I truly am. I don't never wanted to cause anybody pain.
Gotcha. Okay, well, let's get into it. What kind of classes do they offer over there?
I haven't been, reentry, I believe. They offer reentry here, but I found out about this hearing this morning as I was being woken up to learn that I had a parole hearing. I didn't know that when they
talked to your wife. Your wife didn't tell you the date?
No, sir. I haven't been able to get in touch with my wife for a year. I tried calling her last night. I don't know if it's spam blocking on her phone, but no, sir. I haven't been able to get in touch with anybody but my sister.
Okay. Any contact with your son? Do you have any contact with your son at the present time?
I can't get in touch with, besides letters, sir. I've written them. Because I can't get in touch with them through the phone, and they don't have the account. I don't. The only contact I have with the outside world is my sister's.
Got you. Okay, and what about sex offender training? You hadn't had no sex offender classes?
No, sir.
See that, and that's they don't even offer that day. I would take it.
No, sir. I think you have to go to Bossier or
We're gonna get you. You need those classes before you're released to the public, in my opinion, anyway. And
yes.
So your sisters and all, none of them wanted to come today to speak on your behalf, or you didn't know?
One's in California and one's in New York. I didn't know.
Okay, I got you.
I had no idea, sir. I didn't know to let them know.
I got you. Okay, and I want to note that you scored a 2 on your static 99, which is not good. It's not good.
What is that?
Static 99 is a sex offender tool that says what's the likelihood of you reoffending, and you had a moderate risk, which is that means not really good. Mr. Doom, I'm gonna say this because obviously you had a DWI before and you had an indecent behavior with the juvenile. What happened with those charges?
The DWI was
About DWI, what happened to the indecent behavior?
The charges were dropped.
Okay.
I believe.
Okay, yeah, the district attorney, they didn't proceed. Okay, and you also had an aggravated arson and a cruelty to juveniles.
That was in Calcasieu Parish, and that was dropped.
Okay.
That was somebody trying to attack me. And the blood that they saw on my son when the paramedics checked,
no,
it was
that's
my
not
blood.
The same thing. That's not the same thing. This is when you poured gasoline at the strip club, Cloud 9 Gentlemen's Club.
That was the club I was managing.
Okay.
And that was dropped because the guy that filed them was trying to get me out of the situation. Those charges were dropped.
Okay. And then, of course, we have the instant offense. You do have opposition from the district attorney, sheriff, and attorney general, all opposed. And of course, you've heard from the victim's opposition. You know, the biggest problem is you have total lack of classes. I mean, I think you have one class. And you definitely need victim accountability, victim writing, you need sex offender class, you need all kind of stuff. So right now, that's all the questions I have.
What's
Yes,
your
sir.
level of education?
Say that again, ma'am.
What's your level of education?
High school.
You graduated?
No, ma'am.
Why not?
I went to work. I started working.
And so when did you find you had a parole date? When did you learn that? Just today?
This morning.
And so prior to this, you never inquired about programs there?
No,
Just
ma'am.
because you know you needed them? Regardless of parole or not.
Ma'am, say that again.
Regardless of whether or not you had a parole date, you never inquired for program participation?
They don't have any classes like that here, ma'am, and you
I thought you
can't.
said they had reentry.
They do. They have reentry, but it's picked. You can't apply to it. They pick inmates that are close to release date, and
Okay.
those.
So do you have any write-ups?
No, ma'am.
Sergeant Hill, is he still in the room?
Yes, ma'am.
Sergeant, is there anything you can tell us about Mr. Doom?
Well, he's been our hall man, our laundry man for like 3 or 4 years. And he has never been a problem for us.
Good, thank you.
Now, the programs that he needs, we don't offer them here. Like, we don't have a sex offender class, and our reentry ain't really the reentry. Most of our guys, when they go to reentry, we send them to another jail.
I see. All right, well, thank you, Sergeant. We appreciate that information.
Yes,
Mr.
ma'am.
Doom, I don't see any other questions, so Mr. Freeman will be voting.
Okay, Mr. Dune, biggest problem, like I say, you have total lack of classes, and your criminal history isn't the best in the world either. My vote today is to deny, but I also request that you be moved to an institution that they have sex offender class. I definitely think you need that before any release date. So my vote is to.
Mr. Byron?
I concur with Mr. Freeman, deny, same reasons.
And my vote also is to deny for the same reason. So, Mr. Doom, today your parole's been denied, but we'll ask if you can be moved to another facility for programs. Good luck to you.
Yes, ma'am. Thank you, ma'am. Y'all have a blessed day.
No.
All right. Well, denied. So good. Keep the sex offenders back there and classes and all that. Anyway, after something heavy like that, maybe we should try and go back to something a little bit lighter, shall we? A little palate cleanser. We like to do that after the heavy cases. I see Judge Simpson is finally back from being private, so let's see what he's got going on.
Seconds area appearing for plaintiff.
Your name?
Lloyd.
All right. I've had the opportunity, this final settlement conference, to talk to the parties. I'll give you the court's understanding of the agreement, and I'm sure I'll put it in the terms as I understand it. This case will be resolved by way of a consent order or conditional dismissal, that the defendant is agreeing to vacate the premises by 4 p.m. on December 20th, that Saturday. All right. That she will also then execute the necessary documents, but she'll pay her November rent now. She will timely pay her December rent plus $175, which will represent court costs. She'll pay that with her December rent. That plaintiff will give a neutral reference to her for any further leasing inquiries, that there'll be a mutual release signed, and that after paying the December rent, following all the rules and regulations, turning in her keys and vacating the premises, that come January, she will not be obligated for any additional rent, and there'll be a release of her, basically her lease. think I got everything. Did I?
That, if, in the event that she failed to vacate, that we would obtain
Right.
immediate judgment, and get rid. But if it was a violation of a different part of this agreement, there would be a 5-day objection period.
You understand that? Especially the first part we talked about, and that is that if you got to make sure you move, that way there won't be anything. The case is dismissed. As soon as I sign that document, it'll be dismissed and remain dismissed as long as you're in compliance.
Okay.
Right? And the other part, and it's an important part, and I kind of explained it, and I told the landlord that I would explain it. You need to make sure to follow all of the lease obligations that you're currently under while you're still there. All right. So without going into all the details about what we talked about, you just have to be you, do the right thing because of what the ultimate goal is, right?
Mm-hmm.
Got it?
Yes.
Okay. So what I will do, we place those terms on the record. I'm going to adjourn this out to the 18th, isn't it?
Yes.
All right, to November 18th. I won't need you to come back. All right, provided all of the documents are signed and they can be sent in, okay?
Okay.
That makes sense?
Yes.
So you need to make sure to give Ms. Gazzari your email address. Look out in your email for that. You were gonna, she did give it to you?
Yes.
Really?
Yes.
She had an attitude. When did she get? Never mind. All right. Okay. So make sure to look out for that. If it's all signed, I don't need to see you. Okay. Next time I'll see you, I'll call you what, Nurse Darby? Is that it? Right?
Yes.
Okay. And you're going to do it, right?
I'm gonna do it.
Okay. That's what we need. Princess, whatever. All right. Princess, you just watched one of the most fantastic lawyers I've known, Miss Gazzari. And so that you know, part of our whole conversation was that she's in criminal justice, but you were going to be a lawyer, then you said, no, it's too much school, and you just didn't.
No, it's not gonna be crime investigating. I still.
I don't even know what that is. That's TV. Be a lawyer. Then you can investigate whatever crimes you want. We'll talk. I'll probably send you a subpoena, summon you in here, and just sit until you give in to me. All right, folks, I do have to, and I'll do this now. It'll be in writing, Ms. Darby. I do have to apprise you that this is a consent agreement. You're unrepresented by counsel. From the time of my signing, you would have 3 business days to think about it. If you believe that there's some legal reason, something you didn't understand, some right you didn't assert, you'd have to file a motion with the court within that time frame. You understand that?
Okay.
Okay. Doesn't mean that I'd grant your motion, but you'd have that period to think about it.
Okay.
All right. Fantastic. Folks, thank you for working it out.
Thank you.
Everybody have a great day. And that's November 18th at 9. But hopefully we won't see you there.
Thank you.
All right,
In all
Judge Simpson in good spirits.
Thank
Hear me?
Yes, Judge Simpson in good spirits this morning. That's good. Doing civil cases. I think he's in a different courtroom this morning. There's something going on there. I'm not exactly sure what's happening. All right, we'll keep it a little lighter here. Let's see what's happening. I guess we'll check in with Judge Dad. It's been a while since we've been an hour or so. We'll see where Judge Dad's at right about now. Yeah, so we'll keep it up here for a little bit, and then we'll we got a lot of other places we can go. Maybe we'll go back to Louisiana. I don't know. It's that kind of a day, but we'll see. All right, here's Judge McNally. Well, I thought Judge McNally was up to something, but he's quiet right now. And that's not my audio. That's not me pushing any buttons. I think he's just waiting for somebody to come on down. Let me see what we got here. All right. Judge Dad, I went to you. See, the reason normally I would have this a little bit better queued up, but we lost our tab audio, so I just have to kind of wing it. But at least it doesn't mean that the audio cuts out or drops out. But Judge McNally, I know they were having trouble with the audio in his courtroom earlier today. So maybe that's what's going on. Let's see. Well, all right. Well, we'll come back to Judge McNally in a little bit. In the meantime, let's go back to Texas and check in on Judge West. Seems like everyone's having some troubles today.
Good morning, sir. You're Lenny Ledet?
Yes, ma'am.
And Mr. Ledet's case is set for trial in cause number 23, DCCR 0783, set for trial to begin with jury selection Monday, November the 17th. And what is everyone's announcement?
That's really good. Because we're not quite ready. We've been going through discovery and there's some lab reports that I need to go over with him and with the prosecutor as well that I just saw. There was 3 sets of reports, different addendums to the lab report. And
When were those? Have they not been up?
they've always been available. Yeah, they've been available.
Okay, so y'all got a couple of weeks, since we're doing this early, I will number the case. Obviously, it's one of the older cases and he's in custody and it's time to get it moved, so it will be numbered. So make sure you get with Mr. Hoffpower as quickly as possible, go over all of that with Mr. Ledet. If anything changes with regard to any plea offers, the last I saw was it was a 20-year offer that was rejected. If anything changes, it needs to be done quickly. So you guys get together if there's any questions.
Judge, I believe that the last one was 15 years in my understanding.
Was it?
15 was the last one.
Mine's been pretty shit. No, it was, I think, and he rejected, Judge. He's not interested.
Okay, I just don't see that another one was done, but that's fine. As far as, you still want to go forward with trial, correct? All right, well, Mr. LeBlanc will be out to see you this week to go over everything and prepare for trial. Get with Mr. Hoffpower this week so you guys have plenty of time to go over what everybody has, then we'll go forward from there. All right, you can go back with the bailiff, sir.
TCF Live. It is Tuesday. We're hanging out here with Judge West, Jefferson County, Texas.
Mr. Samuel, you've got Tarini Thomas. It's a sentencing. Is Chip? I haven't seen Chip. Oh, you're here. Okay, I see. I see you. You were hiding.
I'm strategically placed.
Yep. Oh, I just tore it though.
Unmute.
Good morning. Good morning, you're Tarini Thomas? Tarini, and Ms. Thomas was placed on, well, first, this is cause number 13, 18010. Ms. Thomas was placed on probation back in April of 2016. It was a 5-year deferred probation for the 3rd-degree felony offense of forgery of a financial instrument. And a motion to revoke was filed October 25th of 2018. Ms. Thomas was arrested, it looks like back in July of this year, pled true to counts 1, 2, and 3, which is failure to report, community service, and behind in the fees, obviously. And so I've received the updated report. Has everyone had an opportunity to review the report?
Yes, sir.
Are there any additions or corrections to that updated report?
No, not to mistake.
Is there any, as from, I don't have a choice here, correct? I mean, I have to revoke.
Yes. Yes.
Okay, Mr. Samuel,
Your Honor,
argument?
after visiting with Ms. Thomas, and I've known the family for a long time, this just snowballed out of fear. Once she could not find a job, she finally found a job over in Houston, in Humboldt, and she was gonna try to make payment, get the money to make payments to get right. And it just snowballed from there. So she's at the mercy of the court. She takes full responsibility for what has happened. The only thing she would, one of the things that we discussed and she mentioned, she would like to make whole by taking care of the financial responsibility in hopes that at least that would give the court an opportunity to consider the minimum sentence. And with that, she would be asking that this be held in abeyance for her to work to get this payment. And she believes she can get that within 30 days and come back and ask for the minimum sentence.
She absconded for 7 years.
We understand.
Yeah, I mean, I can't, there's that, I don't feel like that is an appropriate option to let her back out of jail to pay something that she had 7 years or more to pay. That's not gonna happen. I respect the ask on that, but when you've absconded since 2018, for me to say, yeah, go back out for 30 days and think we'll see her again is not.
Well, I understand, Your Honor, and I understand the hesitancy by the court, but we all fall short at times and make bad decisions.
No, I don't disagree. I don't disagree. And I'm not looking at the max either. I'm not gonna let her out. She could have paid that for a long time. We're not gonna hold anything in abeyance. Whatever's gonna happen is gonna happen today.
Well, we ask that she be given 3 years.
All right, thank you, Mr. Samuel. Mr. Smith?
Judge, it's a cap of 5. I think that was the greatest gift that she could have been given, so we're asking for 5.
So, Ms. Thomas, the thing is, I mean, you have 0 criminal history. This is your only case, and such a great opportunity was given to you 12 years ago? No, 8, anyway, long time. And you had all the opportunity to get this taken care of at any point in the last 8 years. I don't know that, I understand Mr. Smith's position, I understand probation's position. It's very frustrating when you're given an opportunity and you just ignore it like you did. I also don't know that if we were to sentence you to prison today without any probation, that 5 would probably not be what was the offer. But I get the position. I'm going to, at this time, find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the 3rd-degree felony offense of forgery of a financial instrument. I'm going to sentence you to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Samuel. Good luck to you, ma'am. Thank you, and thank you for being here, ma'am. See, is there a Mr. Salinas here? Mr. Salinas? Mr. Hoffpower, have you spoken with him?
I spoke with him 2 weeks ago.
Okay.
Without having, I've got the courthouse here.
I'm sorry?
I've got a video here for him to review with his client.
Oh, okay.
About discovery.
Gotcha. Okay.
I haven't spoken with him.
Can y'all check on him? Thanks. Let's see, Ms. Holmes, you've got Robert Davis. It's a competency. Good morning.
Good morning. How are y'all?
Good, how are you? No. He came back from John Dunn, so now I've got to send him for the year. He went for the 120. I think that's what this is. Yeah.
Got to.
Good morning. Are you Robert Davis?
Yes, ma'am.
This is 24 DCCR 1020. Mr. Davis is charged with obstruction or retaliation. Was previously found not competent to stand trial and sent to the John Dunn Behavioral Science Center for competency restoration for a period of not to exceed 120 days. We've received the report from John Dunn Behavioral Center, and that's dated October 15th of 2025. And along with that packet, there is the chronology and what was done there with regard to competency restoration attempts. The finding by Madeline Gabe, Dr. Madeline Gabe, is that he is currently not competent to stand trial, and an extended civil outpatient commitment is being recommended. In addition to that, we received a report of competency to stand trial evaluation, and that was issued by the examiner, was Dr. Cassandra Hayes. It is also her opinion that Mr. Davis is not competent to stand trial, and that further treatment for competency restoration under a civil commitment would be appropriate. And we also received a physician certificate of medical examination for mental illness from Dr. Stocks with the finding that so this finding is that Mr. Davis does not meet all of the criteria for inpatient commitment, but does for outpatient commitment. The finding is that he is mentally ill, that mental illness is severe and persistent, and as a result of that, if not treated, would experience deterioration and further issues. That's dated October 15th of 2025. There is a second physician certificate of medical examination for mental illness from Dr. Gabe. Her finding is the same in that the recommendation is for outpatient commitment, and the same finding of mental illness being severe and persistent, and that as a result of that, if not treated, would experience deterioration of the ability to function independently. Other than that we've received, is there any other evidence with regard to competency?
No, Your Honor.
And so obviously for the record, we do not have here in Jefferson County an outpatient competency restoration program. And so based on that, if there's no other evidence, I am going to take judicial notice of all of this in the court's file, find that Mr. Davis is currently not competent to stand trial, find that he is mentally ill, and that as a result of that, if not treated, would experience deterioration of the ability to function independently to the extent that he would be unable to live safely in the community. And find that based on the fact that we do not have an outpatient competency restoration program, I am going to find that inpatient treatment is required because of that, and order inpatient treatment for a period of not to exceed 1 year as a civil commitment. Obviously, if we receive notification that competency has been achieved before then, we'll get Mr. Davis back here immediately and go forward with his case at that time. All right, you can go back with the bailiff.
All right. We had a couple of interesting cases there. The one before that, you don't have a criminal history. If I understood that case correctly, this lady didn't have a criminal history. Was in front of judge for how long there? Well, had her case pending for, well, she had absconded for 7 years. Finally, they got a hold of her. They brought her back in. She had all this time to pay off, the forgery, and didn't do that. And so now, as a result, she's going to go to prison. You were on deferred adjudication. All you had to do was pay. I mean, that's it. And the other conditions of probation, like, not pick up any new cases. That's all you had to do. Wow. All right. Well, that's another day in the life of Judge West. All right. Let's see. We've got a lot of other places we can go here if I can. I think I broke something. Oh, well, let's keep it going here. Let's see what's going on up in Wisconsin. See what's happening with Judge Morgan. Yeah.
We will go on the record in the matter 23 CF 169, 23 CT 58, 25 CF 9.
Oh, I think Judge Mogan just broke. I don't think that's my audio.
Special Prosecutor Marco to my client. We're not agreeing this time. However, I belatedly got Mr. I got the discovery this morning, belatedly on my part, that for Mr. Stewart. I would ask for one more status for the following reason, because on the OWI charge, Mr. Stewart is planning on working with Ms. Anderson for the IDIP.
Setting this for trial. These are too old. We're dealing with a 23 case. Actually, we're dealing with two 23 cases and a 25 case. So we're setting them for trial. It's too long.
Yes, sir.
So with regards to which case would you like to set first, Mr. Marco? Would you like the OWI third or the THC, either one? And we're going to need lab for both. So, and I'm going to guess, since it's such an old case, we do have or should have the lab results.
Yeah, I would look at 23 CT 58. I'll just get over to that case.
While we're waiting for Mr. Marco to identify the lab analyst so that the court can call and get this matter set, what is the offer that has been received that is being rejected?
The offer called for Mr. Stewart to plead to one of the felony counts in 25 CF 97 and in an OWI in 23 CT 58 with other counts dismissed and read in, calls for standard terms for the OWI and a PSI on the 25 CF 97.
PSI free to argue,
Yes,
capped or,
I don't remember if it's capped, but
okay, all right. In the time being, Mr. Stewart, I'm going to set the matter for trial and I'm going to set I'm also going to set the 23, or the 23 CF matter for trial as well. So I need that lab analyst because we're going to set 2 trials. In the meantime, before the trial comes, you would have the ability to participate with Ms. Anderson at your choice, but knowing the risk that it may go to trial or it may not. But that could serve in your benefit with any other negotiations with Mr. Marco. But these are very old cases and I need them to move. Mr. Marco, do you have the lab analyst for the 23 CT case?
Michael Knudsen, State Lab of Hygiene. Would you like their number? How do you do this? Your Honor, do you call them and schedule?
I sure do. Is it the 2031 ending telephone 608-266-2031?
I've got 608-224-6241.
6241.
Your Honor, and Dean Marco, sorry. Could I suggest that if we're going to try the 23 cases, I would suggest that having the 23 CF 169 first would make more sense because
I'm setting them both, so we'll just see what
Oh,
happens
in terms
the
of
scheme
availability.
how the lab analysts and those dice roll. That's what's going to happen, quite honestly.
Yes, sir.
And what is the is it an FX number?
23FX010543.
All right, and can you locate the lab analysts for the other matter too, please? And I will go off the record right now and call the hygiene lab.
All right, Judge Mogan is on the lab.
Toxicology, this is Susan.
Hi, this is Judge Mogan in Burnett County, and I am calling to set an OWI trial with Mike Knudsen.
Okay.
And do you need the FX number?
Hang on. Yes, I can take that now.
FX, it would be 23 FX 010543.
Patrick Stewart?
Correct.
Okay. And the date?
Well, Mr. Marco and Mr. Keen, could you do March 3rd? And that would give you sufficient time to complete the program if that's the route you wish to go.
Thank you. Yes, I'm available March 3rd.
Mr. Marco?
Yes, I would be available March 3rd.
All right, March 3rd, does that work?
Actually, yes, you would be a number 1 with Michael.
I so appreciate it. Everything is falling into place. Thank you. We will take March 3rd.
Can I just get one last thing from you? Can I get a contact name and phone number, please?
It would be Aaron Marco.
715-468-4670.
All right, perfect. That's all I need. Thank you.
All right, thank you so much.
Bye.
Thank you. Now let's get a final pretrial. Mr. Marco, could you do, and Mr. Keen, February 12th at 10?
Yes.
I'm sure I can, Your Honor. I'm just double checking.
Okay. All right. So we're not on the record yet, but Mr. Stewart, if it is your intention to try and do that program, this gives you enough time, but you have to start it immediately, like
Okay.
right away, okay?
The idea program.
Yes.
Okay.
And so see, I'm setting it, I'm doing what I need to do for my job, and I'm still giving you time to do what could benefit you,
Okay, thank you.
okay? All right, now other lab, Mr. Marco,
It does not appear as though that has been analyzed.
from a 23 case?
It's marijuana. I just got the case. I wasn't on the case for the first year and a half.
I mean, that makes sense. I'm not coming down on you at all because I don't even know if you've been on the case that long. Well, then let's just go ahead and set that one and we'll do it after March and then Mr. Marco, you can see about getting it sent in.
Yep, absolutely.
What about April 7th?
I am available.
Mr. Keen?
I'm available then as well, Your Honor.
All right, we'll just set, right now, as of right now, we'll just do the February 12th at 10 for a final pretrial for that one as well.
Yes, ma'am.
Because quite honestly, if you're looking like you're going to accept the agreement, we should know by then with all of it, right?
Yes.
Okay. Back on the record, same appearances. As previously noted, the court has now set trial dates for the 23 CF 169 case. The court has set April 7th for the trial date. For the 23 CT 58 case, the court has set March 3rd for the trial date. We are a number one with lab analyst Mike Knutson. We have set a final pretrial date for February 12th at 10. The court has set these dates for trial to keep the calendar moving and to keep the cases and the disposition continuing. However, it has been scheduled with enough time to allow Mr. Stewart to partake in the IDIP program and to have the benefits of any perhaps offer that's been extended and or to be able to continue to negotiate with the state. So those matters have been set. Anything else we need to discuss, Mr. Marco?
I don't believe so. Thank you.
Thank you, Mr. Keen.
Yes, Your Honor. The court in 23 CT 58 had published an order on October 8th forfeiting bond. However, and that was for a failure to appear on June 9th. However, on June 9th, the order was that was for Mr. Stewart to appear within 30 days for it to be forfeited, and Mr. Stewart appeared June 20th.
Talking about what in October? I have nothing signed in October.
And
Are you talking 2024?
no, October, the 2023 CT 58.
Okay.
Okay. An order was published October 8th this year to forfeit bond of $1,500.
Yes, I see that now. It's only in the one case. It's not in the other matters.
Right. However, the the proposed forfeiture of bond, there was.
File a motion, file it in paper.
Yes.
All right. And
Yes,
then
sir.
we can, I can get the state's response and then we can
Yes,
go
sir.
from there. Because it's kind of, it's hard when you're on the spot, when you're trying to remember what happened back in June versus what happened in August or whatnot. So go ahead and file something and I'll take a look at that.
Yes,
And
sir.
we'll address that. Mr. Marco can put in his 2 cents and the court will look at all the facts, okay?
Yes, sir. I mentioned it because it was posted as an order without a hearing, but fair enough.
Well, generally, that's what happens. They get 30 days to be able to file anything in the court. Apparently,
Right.
nothing was filed. Then the state prepares its order and the court signs it.
Right.
Okay. All right. So anything further from that?
No, Your Honor.
All right. Thank you. Then we are adjourned.
Thank you, Your Honor.
Thank you.
All right. That's what's happening right now in Judge Mogan's court. Maybe we'll come back there. Against my better judgment, let's go back to Louisiana. Maybe we'll get something that's not a denied. Maybe we'll get a feel-good story. You know, maybe this will be a real redemption arc for the day today. I feel like we really need that. It's a Tuesday. It's been kind of an interesting day, but let's see what's going on with the Louisiana Board of Pardons and Paroles.
Tuesday, November 4th, 2025. Morning, sir. Could I get the officer there to introduce yourself for the record?
Yes, my name is Carl Kamak. I'm the video conference officer.
Okay, thank you, sir. And this is Mr. Goods?
Yes, ma'am.
Mr. Goods, good morning. Would you introduce yourself? Tell us your name and DOC number.
My name is John Goods. My DOC number is 482478.
And you have counsel, do you have Ms. Bridget Brown there with you this morning?
She's not with me in person, but she's on Zoom. Yes, ma'am.
Okay,
she couldn't be here.
Okay. And here we have Ms. Tammy Brown here with us in Baton Rouge. You want to enter your name for the record, ma'am?
Yes, Attorney Tammy Brown here on behalf of Mr. John Goods.
Thank you.
And Chairwoman, this is Bridget Brown. I'd like to enter for the record that I am present. I am in Tallulah. I appeared at the prison this morning, an hour before this hearing was scheduled to start. The warden and two of his employees were very polite and they escorted me off the premises because they explained to me that they do not allow lawyers to be present next to the inmate while the parole hearing is going on. So they escorted me off the premises and explained to me that I could participate by Zoom, but I was not allowed. So I didn't not show up. And I wanted to be clear that my efforts, and I've done 1,000 of these hearings, I've always gone to the prison, sat next to my client and participated. This morning, I was not allowed to.
Yes, ma'am, I appreciate that. And it's our understanding that Ms. Tammy Brown will be making a presentation. We'll ask her to do so shortly.
Yes.
The case was assigned to Mr. Barra, so I'm going to turn it over to him. You want to take her position?
Now, we're good exhibits.
All right, Mr. Good, it's alleged that you have violated the conditions of your parole in the following manner. Number 3, on 12/10/24, you were arrested in Madison County, Mississippi on a warrant issued by Louisiana Probation and Parole and Franklin Sheriff's Office during a stop by the Madison Sheriff's Office. How do you plead to that?
He pleads not guilty.
All right. Also, on or about November 2024, Franklin Parish Sheriff's Office issued a warrant for John Goods on the charges of rape, amended to domestic abuse, battery, second offense, and domestic abuse strangulation. How do you plead to that?
He pleads not guilty.
And you were also arrested for committing obstruction of justice. How do you plead to that?
He pleads not guilty.
All right. So we plead not guilty to everything.
That's correct.
First question is, why were you arrested over there in Madison County?
Mr. Goods, go ahead and explain.
Well, Miss Thornton, my girlfriend, she had tent in her window, and they pulled us over for that reason.
No, he's asking you, why were you in Mississippi?
I was going to my daughter's graduation. She was in college for nursing. I was going to her graduation.
And he wants you to explain why you were there. Who gave you permission to be in Mississippi for the graduation?
Well, my parole officer, Burgess, gave me permission. I asked him prior to going, and he said, it's okay. You can go, Mr. Goods. And so he asked me for a date. And I say, I don't know at the moment, but when the time come, I'll call you and let you know. So I called him on a meeting app, and he said it's okay, you can go. And right here on this paper, Agent Burgess was questioned by Good's lawyer regarding the violation. Agent Burgess said he does not recall discussing Good's attending his daughter's graduation, but Agent Burgess said it is possible he told Goods it would not be a problem for him to attend graduation. Agent Burgess came to my house. I don't remember what date. And he told me, Goods, it's no problem. Then me and Agent Burgess started talking about our problems. He had problems with his wife or whatnot. Then I talked about my problems. And I had my kids. I had two of my kids. We laughed, say they're gonna be okay and whatnot. And I said, Agent Burgess, my daughter is graduating for college and I need to go. He said, man, ain't no problem. Go. But what he did say what the date. I didn't know the exact date. And Miss Thornton, she was there. And she is a witness to that. In his paper, know what I'm saying, he admitted that it was possible on the hearing and recommendation.
Keep reading the next line after you said he would not be a problem for the attend graduation. Read the next line.
He said, however, Agent Burgess said he would have told Good to report to our office before he left to get a permit.
Did you go get a permit?
Sir?
Did you go get the permit?
He never told me to come get one. He never told me to come get one. He just said it's okay to go. And whatever Agent Burgess
You didn't know you needed a travel permit to go out of state.
Did I know? Yes, sir.
Well, that's kind of what the point of the argument is. You know, he said, I would have let you go, but you would have needed a permit. I mean, and that's what you signed on your conditions of parole that says you're going to have, you know, that's the problem right there in itself.
Yes, sir. But I just doing what he said.
All right. So let's talk about the next thing where it says they issued a warrant for you for rape, and then you got reduced, amended from second offense, domestic abuse battery, and domestic abuse strangulation. What happened there?
The night at the house, what I call like fun house, at my mother's house, I get a call from my girlfriend, my fiance, Miss Thornton, and she wanted me there with her. And I was with someone else. Miss her name, Miss Quosha Robinson and Kelsey Heckert, two women that was there with me at the time. And when I stopped answering Miss Thornton's phone, she started to come. She come to Winsbury. She have a key. She came in while we was in the kitchen, sitting down talking. And Miss Thornton came in, and I was trying to see who was at the door. And she was like, oh, I know that effing girl Kelsey in there, because today her birthday. And she started putting on my shirt, pull my shirt up, and she started punching on me. And I'm falling, going back, and I never hit her at all. And so the girl Quosha was like, let me go home. I don't got time for this nonsense. Kelsey took out running the room. And when I left to take Quosha home, and then I come back, Gigi was still there. Miss Thornton was still there. And she was like, I'm sick of this shit. All you do is cheat on me. This the fifth woman. And I'm like, baby, chill out. Just chill out. We was just talking. We wasn't doing nothing. We was just talking. And she like, I'm sick of this shit. I can't take it. And then I said, baby, chill out. everything is good. And then we sit down, and then we start talking, and that thing know we start having sex. And then we go from the front room to the bedroom. And as we was in the bedroom, the door was still open, and we started making love. And she moaned and said, "Baby, why are you doing this? I love you." And I said, "I love you too." And we had good sex. Miss Kelsey, she passed through or whatnot, because normally we used to do threesomes. But me and Kelsey and Miss Thornton never did a threesome together. And so as the night passed, probably like about probably like 2 o'clock, not for sure. Me and Miss Thornton, we left out. I asked her, was she gonna come spend the night with me at the house, 3302 Earl Drive. She said, "No, I'm going home." I said, "Okay, I'll see you tomorrow." So as we walking out, Miss Kelsey Heckle was in the front room, sitting down. And I think Miss G just said, "Hmm." So as we walking out, I opened the door for her. She left and went her way back to Monroe, and I went home.
So you're saying that everything was consensual and Miss Thornton is lying about all of that?
Yes, sir. Yes,
All
sir.
right. And condition number 4, that you're arrested for obstruction of justice, and that stems from phone calls you were making to the victim that they were recording to try to influence the outcome of that trial. What do you got to say about that?
Well, Miss Thornton, she have a sickness problem that I do know of, and sometimes she flips, and I had to call my homeboy, like, "Man, what is the sickness?" His mom and his daughter have the same kind of sickness. He say, "John, man, you gotta be able to know what I'm saying, to learn about it first. Then you can be able to cope with them. If she ain't taking her medicine, know what I'm saying, that medicine not working, she need a higher doses." So I'm telling my best, baby, make sure you take your medicine. Because when she take her medicine, she calm, she nice, she happy. But when she off her medicine,
Let me interrupt you. I didn't ask you about her
okay.
medicine. I asked you about
Okay.
the obstruction of justice with the phone calls from the detention centers. Did you make those phone calls? What was the point?
We both were calling each other. Yes, I called her at the time, but I was never told that it was I had a restraining order against her. I was told to after everything when I was indicted. That's when they put I guess I never seen nothing of no restraining order. I never seen a piece of paper. No one never told me nothing about that. So I don't understand how I got obstruction of justice. You know what I'm saying? When I'm just trying to help my girlfriend to pass being stressed out, being confused, because her lawyer told her, you know what I'm saying, not to go to the grand jury. Her doctor told her not to go. I didn't understand where this obstruction of justice come from. So I get a call from the judge, sir.
It comes from when Deputy Touchette listened to the phone calls and indicated that the nature of the phone calls indicated that Good was trying to sway or influence the victim's testimony for the upcoming court proceedings. So that's where the obstruction of justice. You were trying to tell her what she should do or influence her to how to testify at the upcoming, and that was considered obstruction of justice.
If you listen to the whole conversation, you will see it was no obstruction of justice. You will see that I was kind of console her. If you listen to every section of the tapes, and then they ain't only got the tapes, you know what I'm saying, where I told her, it's gonna be okay, baby. You don't have to go if you don't want to go, because your lawyer already told you so. I was saying on that point, not because of me, because at that point, if you listen, it was another tape recording saying when her lawyer was on the phone, I told her, "Baby, just go." I said, "Go." I said, "Go ahead, tell the truth." That's what I told her. If you listen to all the tapes, I guarantee you, it was set up and designed to put me in incarceration. At never time I was trying to stop her from going. Only to console her, sir and ma'am. Only to console her. If I promise, if y'all listen to them tapes, the whole tape, all of them, and you will see that I'm telling her, ma'am, the GG, do as you please. I can't make you go. I can't stop you from going. Your lawyer told you not to go. Your lawyer told you to plead the fifth. And you will see on her papers, the lawyer sent to the DA. And even the DA told her she didn't have to come. But when she got up there with my father, they said that you come sign a paper and we'll get off the case. But they then pursue to get her a summons to come to the grand jury. She chose not to go. I basically want her to go to tell the truth because I want my name cleared. I want my name cleared. These people came in with a plea that, know what I'm saying, with no contest. If I was guilty, I would have took that plea. All I did 20.
Every two-chat that listened to the calls and made this statement that the calls indicated Goods was trying to sway or influence the victim's testimony in the upcoming court proceedings. He lied to?
Say again, sir?
Well, I'm just trying to figure out, Deputy Touchette listened to the phone calls and indicated that the nature of the phone calls that Good was trying to sway or influence the victim's testimony. Were you trying to sway or influence the testimony? Did you say, no, you shouldn't testify? That's what I'm getting at. You know,
No, sir.
Around it.
I only was trying to console her. I said, you would be, because she didn't want to come. She said she's scared of Winsburg. She tried many times to come and drop charges. Even her lawyer came to do a drop slip. And these people, and then I was not indicted. And then
you keep going back to the same thing.
Come on.
I'm still under obstruction of justice. I'm on the phone call. When you talk to her on the phone, what did you tell her? You tried to console her. The deputy says you tried to influence her. Two different things.
No, sir, I did not.
Totally different things.
No, sir, I did not try to influence her. No, sir.
Yeah, that's at the end of that.
Okay.
I understand. All right. All right. Did you end up getting found guilty at a trial for these charges?
Yes, sir.
No.
How can you still be? Go ahead.
No, the trial was on violation of a protective order and for simple failure of a.
So they were reduced charges that he found guilty of.
Reduced to misdemeanors.
You were his lawyer for them?
Yes. I was one of the attorneys.
Did you advise him he could be revoked for those charges?
Prior to the trial.
Okay. And he pled anyway.
Okay.
Well, he didn't plead, he was
found guilty. Okay, thank you.
Okay, I don't have any more questions at this time. Let's hear from go ahead, Ms. Tammy, you go ahead.
Well, I will let the witnesses speak first.
All right.
And I'll speak again.
We have
have
Tammy Warren. Ms. Warren, go ahead and tell us what you have to tell us.
She needs to unmute. She needs to unmute her phone. She doesn't know she needs to unmute her phone.
Okay.
You can speak.
Yes, I'm Tammy Warren.
All right, will you go ahead and tell us what you have to tell us about Mr. John Goods?
I'm a ex-co-worker of Miss Thornton. And Miss Thornton has been telling me off and on things about her and Mr. Good's relationship. I'm an ex-employee with her. And Miss Thornton will always bring their outside business to work. So I told her to discuss that at home. She looks up to me, and I tell her different things. So when all this occurred, she told me, she said, I'm going to help Lil John. I say, help him on what? What's going on? And that's when she permits to tell me about the rape. And I say, how do your man rape you when you stay with him? And she was upset about that. And I say, why did you go to the hospital if you're going to help a person? Some lies are being told. And she say, I don't have a reason to lie. I'm just going to cut Lil John off. I say, well, do that and leave your outside business out. Then she go back and forth with me for a minute. We was at work. I was working with her at the time. And we go back and forth, and me and her sit on the phone and talk for hours. She was upset easily when he's go talk to other women's, or she can't reach him, or you see another side of her. Her whole personality changed when she can't get a hold of him. And I used to tell her, that's not the way to go, Gigi. She said, well, he's stressing me out. I said, you're stressing yourself. Me and her would have late night conversations. And she said, I'm going to help him. Now, this is what she told me. Then she'll go back into a state of mind and say, hey, I'm just going to cut this off. So all of this occurred. And when, like I told her, if you're going to cut a person off, don't lie to cut them off. That's just not going to make it. Just cut it off. And she could not do it. She'll call me another night and say she caught him with another woman. She's seen him. She's not in Winsboro. She's not going back. And what she's not going to do, but she turn around the next day and do the same thing. She go back to Winsboro from work. She'd be late sometime coming to work, from arguing and bickering. And I told her, I said, well, you stay in Monroe and leave him where he lives. But she couldn't do it.
Ms. Warren, this is Attorney Tammy Brown. Did Gigi tell you that Mr. Goods did not rape her?
Yes.
Did she speak with you about going over state lines?
She told me, she went on to the graduation. She said that she called me and said that they had arrested Lil John and that she went on to the baby graduation, which was his daughter.
Did she tell you anything about her and her sister's plan for him to go across state lines with her after he had a warrant, after she had put a warrant out for him?
She didn't tell me anything until the day they got caught. And I said, well, why did they stop you? And she said the tint on her window. And I said, well, why would they question him about anything if it's your tint? And she said, I don't know. And I said, that don't sound right.
Did she tell you anything about the affidavits that she typed up?
Yeah, she told me about it. She told me before she did it.
Okay, and what did she type up the affidavits to say? Do you know?
I don't know what she said, but when she called me, she said about the affidavits. We spoke on that. And she said the attorney was charging her too much to do the work. And I say, oh, okay. I said, well, who did you go to? And she said, Manny, but they all wants to charge too much. I can do that myself. I can go to the library and do it myself. And she went on North 18th Street in Monroe and she did it herself.
So she wasn't pressured to draft the affidavit. She typed it up herself.
She typed it up herself. She said she can do it herself. She's not going to pay them all that money to do a piece of paper she can do herself.
So whenever she was telling you at the beginning, you said she told you she was being raped. Did you believe that she was being raped at that time?
No. I asked the question, if Lil John raped you, why there was no semen? And she said, I took a shower. I say, well, Gigi, that don't sound right. I say, that is a lie. I say, you are back and forth with this here deal talking about Lil John when you upset. And my words to her as a woman, I say, if he raped you, his semen should have been inside of you. She say, I showered. I say, but his semen do not leave you within 5 minutes. I say, you call about everything else. Why you didn't call me then? She said, I called my mother.
Tammy, did Gigi ever say that if she couldn't have Lil John, that no one would, and she would rather stay in jail?
Yeah, she said she's not gonna play with him. She said, I'm not gonna play with Lil John. That was her main conversation at work. She's not, when I was employed with her, she's not gonna, play with him anymore. Then when I quit and I moved on to another job, and that's her words. And she said, I'm gonna stop playing with Lil John. I'm gonna show him.
Do you know anything about her driving Lil John's father around and going to pick him up and bringing him with her court or to the courthouse?
No, not Monday. She didn't discuss that Mr. John's father was with her Monday. She contacted me Monday and told me that she was going to court in Winsboro, that she had a subpoena issued in the mail. I said, you cannot issue a legal document in the mail, Gigi. I said, are you okay? She said, well, it came to Arkansas to my mother's house. And I said, well, if you live in Monroe, why would they send a subpoena to Arkansas? I said, they can't mail that document. She said, well, I got it. When she attended to, she said, oh, well, I got it. I said, okay. So we didn't argue about that. The only thing me and her bickered about was Monday.
We're getting off the violation course right here. I pretty much heard everything I need to hear right from her. Let's move on to the next person. Ms. Kelsey Hecker.
Good morning.
Good morning.
What do you have to tell us regarding Mr. Goods and what you know about the violations?
I can say the only thing I could speak on is us being at the house, his family house, and me seeing everything that day. When we was at the family house, he had a girl named Quosha over there. I'm always there because if he need me to go somewhere, run and go, do for his son or something, I'm who he call on. I'm who he call on for anything, like to run to the grocery store, do anything for him. So I'm always at his house. And he had a girl named Quosha Richardson over there that night. And we heard the door unrambling, like somebody trying to get in. I don't know if she was getting in with the key or what. But Gigi ended up getting in the house and she just started going out. She started saying, oh, you cheating on me with the which wasn't nobody doing nothing. We was just sitting in the kitchen. And she started pulling on his shirt, and he kept telling her to leave. She wouldn't leave. And this not the first time, this the second time that she done came and did this. He'll be like, Gigi, leave, just leave, or whatever. She wouldn't leave. So the girl Quosha Richardson, she wanted to go home and he took her home or whatever. Gigi stayed there. I went in the back room. He came back. Gigi, they didn't shut the room door. I came out the room door and walked down the hall. Gigi was on top of him, but she said that he raped her. How could you rape someone if you getting on? How could you get raped if you on top of someone? You moaning, saying why you cheating on me and you love him and all that. So as I'm walking past the hall, I see all that. I go sit in the living room. Like a couple minutes come by, she come out. They didn't look like they had been into it. And like she just was happy that she had got the love from him or whatever. And she walked, I guess she didn't like that she seen me sitting on the living room couch or whatever. And she had walked by, she said, So he just let her out and she left. And that was that.
Ms. Hecker, did you ever hear Mr. Goods threaten Ms. Thornton, or who you're referring to as Gigi?
No, she was, when he made it back from dropping Quosha off, it's like she was happy that she had him back to herself. Like she wasn't on none of that. Like when she first came in and seen the girl Quosha in there, she like how she was flashing out. Then when he came back by himself, she was all calm and cool. She wasn't on nothing. She was lovey-dovey.
Did you ever hear her say no, or that she did not want to have sex?
No.
Did you hear them tussling or arguing or any of that when they were in the bedroom?
No.
Did you hear him or see him pull her hair or any of those things or hit her or anything?
No, when she came out the room, her hair or nothing wasn't messed up or anything. It's like soon as he came back from dropping that girl off, she was lovey-dovey. It's like she was happy that she had him to herself again. It's like if she seen him with a female, she would flash, she would lose her mind. Like this woman would go crazy if he wouldn't answer the phone, if he wouldn't, she couldn't get in contact, she would just go crazy. But it's like when he came back there and she had him to herself, she was all calm. It wasn't no fussing, no fighting, no nothing. They was making love.
All right, we'll accept that. Can we hear from Miss Tykia Ponder?
Yes, sir.
What do you have to tell us relevant to the charges and violations of?
I don't know.
Already established that they had sex. We've already established that it's questionable if it was consensual or not, but we still have the victim actually to hear from too.
I don't know. Me and Gigi normally we talk on a daily basis. Like
Okay.
she vents to me, she's do all of this. We vent to each other at the. But me and her, we normally talk. And normally when she texts me about John Good. She texts me about him, telling me how she missed him, this and that. She was wrong for doing what she did, or stuff like that. And normally, she'll call me, up on this hearing stuff. She let me know and told me what she was gonna do with this today, and everything like that. But normally, like this, I don't know.
What did she tell you she was gonna do today?
She said she was gonna hold up. Let me go to it.
Did she send you a text message?
Yes, ma'am. She said, I only called due to the board had contacted me. You can update your family, and if Lee John called. They asked me if I wanted him to be revoked. My answer was no. They said, would I get on the hearing Tuesday and let the board know? I told them yes. Like I told him, I didn't like how they set me up Monday, but I am not upset as I was, but I am willing to get on there.
Do you know anything about Miss Thornton, or who you're referring to as Gigi, contacting Mr. Good's family?
I'm one of the family. She contact me normally.
And has she been reaching out, trying to get in contact with family members and have them to call her?
Yes, ma'am. She hold up. She
What about-
contacted ma'am.
What about her contacting his dad or trying to get the dad to contact her?
Yes, ma'am. She normally go pick him up.
Does he drive?
No, ma'am. She drive him.
So when he would come to court with her, she would have had to pick him up and bring him to the courthouse or bring him to court?
Yes, ma'am. She texted me the other day and she was like, hi. I was trying to get in touch with her because she didn't answer. So maybe if you call her and I can talk. There was my other cousin, Kale. And then they sat on the phone. She would screenshot me that they was on the phone. They talked on the phone for like 2 hours long. She was just venting. That's all she was doing. She said she need her partner back. She was wrong for what she did. She did not mean to go that way. She did not know that it was gonna go end up this far.
Did family members pressure her?
No, ma'am, we don't.
You okay?
Ms. Ponder, does she normally lie to you? Tell you false stories, or is?
See, y'all had a court thing happen last week. What she told me was different from what I'm hearing from everybody else in the court. All she told me was the lawyer turned on her. I don't know how the lawyer turned on her. She said she never knew she was supposed to get on that stand.
But in your relationship with her, is she normally reliable? Does she normally tell you the truth, or do you find out she's lying later on?
I found out she started lying later on. Me and her, we normally talk until I found out some of the stuff she tell me will be a lie. Cause I hear the other folks' opinion about it, and they were like, no, that's not what happened. Just like what happened in court. She told me one thing, but With the people that was hearing it up in court, they said what was said in court.
All right, I think that's all we need from you. We have her, so I think we might as well hear from her.
Wait, let's hear from the attorney first. She
Well,
the victim
you want-
or not?
No, Ms. Thornton first.
Well, wait. You know, we decide who goes when. I mean, she's listed as a victim. Is she the victim or is she in favor?
We don't know.
She
We don't know what she's gonna say today. But
according to the messages that she sent to Ms. Ponder and some of the other family members, she is.
Okay, let's come. All right.
Yeah.
Ms. Shalana,
Good evening. Good morning.
why don't you go ahead and tell us what really happened?
Okay, so basically, you have Tammy Gooding, you have Denise, TK, and you have the one that got cheated with, that I called John Goods with twice. So at first, I was going to get on here, and this is truthfully. All these people, including the lawyer. First of all, we went to court on Monday. I have been told since last Friday I was not going to be put on the stand. Never. I had a subpoena did come to my mom's address on October the 5th. I was there seeing about my mental challenged uncles. My grandmother has dementia. She's placed in a nursing home. So I oversee those two uncles. So I was there getting groceries, paying their bills for the month. When I was there, my mother called me and said, the mail carrier has a certified letter. I went and tried to find our route carrier. When I tried to find the route carrier, I couldn't find her. So I went back to the post office. My cousin worked there, but she wasn't present in the front of the building that morning. So the other lady basically told me, Shalana, here's the certified letter, but you got to sign for it. At that point, I did not know was the certified letter, where it came from, who it was from, nothing. So I had to sign for it. When I signed for it, I looked at it. It said Franklin Parish Courthouse. I immediately opened it. When I opened it, it was a subpoena. I contacted Major Wally, which was his best friend. That is the only person I have been talking to of 2025 for the last 4-5 months. If we're going to lie, we're not going to lie. We're going to tell the truth. All three parties of John Good's witnesses. So this is how this went. Monday, well, just starting the whole ordeal. Let me go from November the 13th. Yes, I have issues with anxiety and depression. I was diagnosed with that in 2018. I lost my grandmother. She was like a mother and a grandmother that raised me when my mom was living in Illinois. So I was a grandparent child my whole life. So when I lost my grandmother, I went in a state of depression. I ended up moving to Sterling, Louisiana, like 4 years ago. Never knew anything about John Goods. I came out of a domestic relationship with another individual. This individual was cheating, had people in my vehicle. I told John Goods certain things that nobody knew. Only me and John Goods, because I confided in him. I confided in him only due to the fact that I had found someone that was true to me. I watched this man he has 5 kids. I watched, bathed, fed, provide. I was doing things that I didn't have to do. When I came in this relationship, I never knew anything about John Good's past. When I'm in a relationship with somebody, I don't care what their past is. I see for myself. Down through the relationship, when I see for myself, I had to see for myself. John cheated on me 5 times. And one of them was with this witness on here, Kelsey Hacker, on Winsboro's homecoming night. He told me he was hanging out. I was tired from work. I did not want to go to no homecoming. And plus, I wasn't even asked, did I want to go? I stayed. I said, no, I will stay and watch these children. That's what I did. So there was a nephew in the living room. That nephew he's real picky on what he eats. So he was just up crying the whole time. So when he was crying, I got up and I asked the baby, are you hungry? I got up about 11:30 that night. I got up. In my head, some told me to go to the Western Street house. When I did, this is the first incident. When I did, I caught him and Kelsey in the room, his clothes down. She had no idea. She said, oh, you got a girlfriend. Yeah, he got a girlfriend / fiance. He has both. He screamed, told her to get out. We had sex that night. We stayed there in that house, got up the next morning, went back over to the family house. Okay, that was over. Yes, I have had conversations with Tammy Gooden when she was employed when she worked for me. But Miss Tammy, if you're going to sit here and lie, because when all this
Hold on. You can't sit here and go after witnesses. I need you to give me the facts of what happened to you. How did you get the bruises around your neck? Were you raped? Okay. How did we end up in court on the battery charge?
Yes, sir.
You can't go after the witnesses and all the stuff about kids eating and all that. I mean, granted, I think you probably feel you need to talk about that, but that's not what we're trying to find out.
Oh, yes, sir.
So try to focus yourself a little better. What we want to know is about that night.
Okay, so that night.
That all the trouble happened.
Okay, November the 13th.
Right.
John Woods had came to Monroe basically on November the 12th that midday. He came, he said, baby, we good. We back together. He wanted to have sex that night. I told him no. So that particular evening, he told me he was going to work on the house that he had purchased. And basically I said, okay, I'm going to take a nap and go to sleep. When I woke up, it was about 10:30, 11 o'clock. I started calling his phone by FaceTime. I started calling his phone by regular phone call. And basically he wouldn't answer. So at that point in time, I got up. I took myself to Winsboro, went to the house on Western Street. This was early morning 13th. When I did go in, I let myself in with a key. When I did go in, he met me in the living room. When he met me in the living room, I heard another voice. It was not Kelsey Hacker. So when I went towards the from the living room to the kitchen, there was a dark-skinned girl. At that point in time, I did not know who she was. When she said, John, I didn't come over here for that. I said, my beef is not with you. My beef is with him because you can only allow what he allow you to do. So I kept asking him, like, why would you keep on doing this same stuff? And he kept saying, baby, I'm sorry. We ain't doing that. We in the kitchen just talking. I said, Lil John, I don't believe you. And I said, the girl came to the living room. We back in the living room now. The girl came to the living room. Lil John just gonna take me home. I said, if he don't take you home, I'll take you home. I said, but you could just have a seat right here. I said, because I don't have anything to hide when I'm talking to him. So basically, he kept on saying, man, because I told him, I said, if you do not give me the answers that I want while you steady keep on doing this cheating and these having on women.
Did your son put in a medical request to see the nurse? It's good.
Keep going. Keep going.
You talking to me?
Can you hold on? One more thing? Just hold on 1 second.
Keep on telling us your version of the story. John, you need to be quiet right now. It's not your turn.
It's the
There's somebody at the facility.
Whose turn is that? Who's talking?
I think that's the
somebody.
It's not John.
All right, disregard the background noise. Finish with your story.
Okay, so basically we're in the living room. The girl ended up walking out the house. She got in the truck, and he said, I'm just finna take her home, Gigi. I'm finna take her home. I said, okay, if you don't come back, I'm about to call Kevin Cobbs. And he already knew I was gonna call Kevin Cobbs. So at that point in time, he did come back. We had a conversation. We were in the kitchen. At that point in time, when he was gone, I walked that whole house. I walked the whole house. Only room I did not go in was the room that he was still fixing on was the master bedroom. And I went to the bathroom because I had to use the bathroom. So the door to the bathroom was open, so it wasn't nobody in there. So if they was in there, it was in the closet. So basically, when I did come back to the living room, he wasn't in the house at that point in time. When I came back to the living room, he had came back from bringing the dark-skinned girl home. And so we came into the living room, had a conversation. He was getting irate, and I said, "Won't you just calm down?" I said, "I didn't got calm. Won't you calm down?" So we both went to the living room. He wanted to have sex, and I told him, "No, I don't want to have sex because it's not going to make the problems go away that you're doing." So basically, at that point, he did go to the went from the living room to the room. I asked him several times, basically, "Why are you doing this? Why are you doing this?" He said, "Baby, you my main woman. You my main woman. I told you I wasn't leaving." I said, "Okay." And I still didn't want to have sex, but we had it anyway. So at the end of the day, when we did leave, Kelsey Hacker was nowhere in no living room. So I don't know where that came from. That must be a story that they're making up. But Kelsey Hacker, she was not in no living room. I never made no hump. I never said none of that. This camera's all in this house. So if I said that, and if she was in that living room, then the camera should have picked her up in the living room because I know exactly where the cameras were. So at that point, me and John Goods only left that house. Kelsey Hacker was never in the living room. And we left. I followed him back over to the family house. And when I did watch and make sure he was parked, I drove myself back home. So we had a little tussle during that night. Now, I do have to be honest. He never put his hands on me. I pushed him. I tore his shirt on that point. But anything else with a medical condition saying that I called you this past week or I tried to talk to you or tell you this or tell you that, no, that's not the truth. And the only reason why I picked Mr. John Martin up is because he doesn't have a car. Mr. John has never did anything to me, never did no kind of harm to me. He just wanted to be involved because of me and his son. He calls me his daughter-in-law. This man done ate at my table. I done ate at his. He done bought me food, etc. But this man has never did anything to me, so I don't even know where that came from. I never said that a family member threatened me, and I never tried to contact a family member even after this. I just had family members calling me, asking me how the case went. And I was told,
I got a question for you. I got a question. You told the police a different story than what you're telling us right now, correct? And you told them that he
when I told the police what.
And you had them photograph pictures of your neck. Your neck is all bruised.
Correct.
We looked at the photographs. How did all that happen? Why did you tell?
How my neck got real red. When my neck was real nails, I wear artificial nails, and I was scratching. And basically, when John was pushing me back, just so, like I said, when he was pushing me back, he basically did not hit me. He basically was just trying to move me away from it. So that part is how the scratch got on my neck, the little bruise. But at that point, when we were in the bedroom, we call it rough sex. His hands went around my neck. So some of that could have been or couldn't have not been. I just know his hands was around my neck in the bedroom. We call it rough sex. So basically, that's why those marks were on my neck. And when I said I never told the police that it was rape. The police told me oral sex, anal sex. He said something about consensual sex is considered rape. I was in a vulnerable stage at that point where I was on my medication. I was on pain medicine for my leg. And basically, when I did contact Winsboro Police Department, the first thing I said, I want to report when my sister told me, you need to tell them that y'all had an altercation or y'all had a disagreement. That's what I told Marvin Scott. Marvin Scott started telling me about his previous history, how he sell drugs, etc. And basically I said, that's not my position of calling you. My position is only to call you to let you know what altercation we had. So basically, he told me, well, I got to call the sheriff's department because I told him I didn't want to talk to you because you related to the family, and I didn't. So basically, that's when he told me that I needed to, there would be somebody calling me later on. I was at work. He told me that somebody else would call me later on that night. I really, at that point, told my god brother I didn't want to do anything else with this. There was never a conversation with the police until 8:00 that night. I had already been talking to Goods prior to a police even contacting me. Those two sheriff's investigators that was contacting me kept calling me, kept saying, Miss Thornton, we need you to come in. We need you to come in. They was pressuring me to come in. They was like, basically, this the only way you're going to get closure. I don't know what kind of.
Let me ask you a question, okay? Because we're getting way off track here. First off, what about the gun in the drawer?
Basically, how that picture came to me was by his ex-girlfriend, Jada Gaines. Jada Gaines was upset with John Goods prior to him dating me. Basically, she sent that picture to my phone, and I basically sent it to him and told him, this. I said, if you don't call me back, basically, I sent him that picture showing basically what she sent me.
I don't know. He kept a gun in that drawer, but he didn't pull it. He kept a gun there, but he didn't pull it.
No gun was pulled on me.
Okay, but there usually was a gun in that drawer, though. That's why you were scared.
Basically, I never even knew a gun was in the drawer. The picture was given to me. So I can't say if Jada was over there, the picture was over there. I mean, the gun was in there or not. I just know what she sent me.
All right.
All right. Thank you very much. Appreciate you testifying for us. All right. We'll go ahead and move on to the attorney.
This is Attorney Bridget Brown. 6 months ago, I was sitting in my office with my doors open for business like everybody else. I've been practicing law 38 years. A young lady contacts me and tells me that her boyfriend is in jail for a rape charge because she exaggerated some conditions about their relationship to the police, and that the police were angry with him about some other things, so they used her exaggeration as a reason to pick him up. I didn't know any of the parties in this case. I live in Alexandria, which is 2.5 hours away from where we are today. That young lady also told me that even though she initially cried rape to the police, she hired 3 lawyers and executed 3 affidavits notifying them that she had not been raped and she did not want to go through with these charges. She even produced for me a letter from the district attorney's office where they said to her, if you don't want to proceed with these charges, please don't come to the grand jury proceeding, and notify us that you're not coming. She didn't just notify them that she wasn't coming and she didn't want to proceed. She hired 3 lawyers who executed affidavits for her. And I stand corrected. She hired 2 lawyers who executed affidavits for her, and she personally executed her own affidavit saying that these things weren't true and that she wasn't going to go through and she wasn't going to appear at the grand jury. Slightly after that, she got a notice from the district attorney's office that she hadn't shown up for a subpoena with the grand jury and they were going to indict her. And based on that, I think that Ms. Thornton is telling you this morning that she was afraid of the district attorney's office. I don't know any of these people. I'm practicing law. They come into my office with the information I get. but she was adamant, like many women are in domestic situations, that she was going to testify that he didn't do anything to her. I didn't know that she was truthful about this, even with the affidavits, until we had the preliminary parole hearing at the prison in Winsboro, in Catahoula, I'm sorry, in front of two parole officers. She testified just to what she testified to today. Nobody raped me. I never saw any gun. He didn't. We had a disagreement. I did, and she testified that I was present when the parole officer told him he could go to Mississippi to his daughter's graduation as long as he was coming back, no problem. That is how she testified at the parole hearing inside the prison. And so I used to have a question in my mind as to why DAs didn't charge certain crimes. That was cleared up in this case because the charge went from rape to violation of a condition of bond. Mr. Goods never got out on bond. The bond condition set in the record says if you get out, you cannot contact Miss Thornton. He and Miss Thornton talked all the time. When I asked if there was any type of restraining order or prohibition against them contacting each other, Miss Thornton brought to me the third affidavit from her lawyer saying, I never asked for a prohibition against talking to Mr. Goods. I don't want that to happen. I want to contact him. I want to talk to him. So imagine my sheer shock at the trial on this past Monday when she got on the witness stand and said that his family and I had threatened her and that we had made certain allegations against her to force her to not either appear at a hearing. I'm an officer of the court. I don't encourage people not to follow the law. I have practiced law for 38 years. My reputation stands for itself. So when she came into court and started explaining that she was changing her story back to what she told the police, she said, it's because you encouraged me to not come. You encouraged me to lie. I don't do that. That's called suborning perjury. So when we get to the hearing, the charge goes down from rape to obstruction of justice to violating a prohibition against contacting the victim if he gets out on bond. Mr. Goods has been in jail for 11 months. He has never bonded out. There was never there was no way for him to contact her except her calling into the jail. When we put that evidence on the stand from the officer who you named earlier, that I said, well, how can he get in touch with her? He's in jail. The response was he's in jail, and she's contacting him. And her story at that point was the family is contacting me and pushing me into changing my story. So the gentleman to your left, Madam Chairwoman, who to your right, who said to you, well, we decide who talks here. You're correct. Let her talk. What is she going to say? I don't know. I don't know. I didn't know coming into this hearing this morning what she was going to say because I have had several different visions and different sections of the story. And because of these missed stories and changes in stories, the district attorney's office, the morning of the trial, I'm a trial lawyer. I'm prepared to pick a case and try a jury of 12 people who have to agree. So on that particular day, they could walk into the court that morning of court and say, we've decided to reduce the charge from obstruction of justice, him contacting her, which was not one of the charges he went to trial on, but violation of a condition of bond. He never got out. He stayed in jail for 11 months. And so when the second one was he contacted her while he was in jail, and simple battery of a dating partner. She just explained to you that there was no simple battery of a dating partner. That she was brokenhearted about some of the women he had dated while he was supposed to be committed to her. So in that vein, the obstruction of justice charge, they never went through with it. They dismissed it that morning. The simple battery of a dating partner. This is the first time she said, no, this is the third time she said he didn't batter me. The first time she went to the police, she said he did. And so the other allegation of Did he go to Mississippi without a travel permit? Sure, he says that he got permission from his parole officer, a parole officer who he had a outstanding record with, no problems prior to this incident. So on the three allegations that we're here for today, obstruction of justice, they didn't put any conviction on him for obstruction of justice, persuading a person not to come to court. You have the letter from the district attorney as an exhibit there. You have a letter from the district attorney saying you don't have to come to the grand jury proceeding. On the second allegation, rape reduced to simple battery of a dating partner, she just told you that it didn't occur. And then on did he go to Mississippi without a permit? He got oral permission from his parole officer in front of his Gigi Thornton. And she was our witness on whether he got permission to go. That was an issue at the parole hearing, at the preliminary parole hearing. It was not an issue at trial. So I will say this to you. Mr. Goods has been in jail now for 11 months. And he was adamant, no matter what they offered, I want to go to trial and clear my name. So, and here we are again. And today is the first time since the three different versions of the story that I understand why the district attorney's office would not pursue rape, why they were coming to a major felony trial the morning of the trial and reduce it to 2 misdemeanors, and why the allegation of obstruction of justice was not pursued, because they did play 3 tapes in court, and on those 3 tapes are Miss Gigi Thornton, her lawyer, and Mr. Goods. And I have said from the very beginning, I represent Mr. Goods. I don't represent the other parties involved in this. And so what we had was a woman scorned. Miss Thornton got on the stand and said that everybody was threatening her and his family was threatening her. My thought is, here are 2 exhibits with which we produced this morning showing she has contacted them consistently and incessantly. The family members that she contends threatened her since we left that trial on Monday. There's a text message which she sent to witness number 2 where she's saying, I'm going to go and tell them that I don't want Mr. Goods revoked. I want, I want to leave all this behind me. I don't know what the story will be tomorrow, but that's what it is today. And then there's a second thing there, a second text there, which proves everything that Ms. Thornton said this morning is true. There's a text where she says to him, you're not calling me back. I'm upset that you dealt with these other women. You would not call me back, but if you don't call me back in 10 minutes, you're going to see how I move. That was the most, and it was after the district attorney's office gave me that text that I realized, well, that's why they're not pursuing rape, because she's threatening him before the arrest. And in the car going to Mississippi, when they stopped her for her tip, Miss Thornton was in the driver's seat. He was on the passenger side. So there was no threat of harm to her, no obstruction of justice to her, no threatening of a dating partner. And for the record, Mr. Goods filed a motion to reconsider sentence. Now, this board is well aware that a felony trial involves 12 jurors. A misdemeanor charge, you're only allowed to have a bench trial. And so we were trying as best we could to avoid a bench trial because I wanted to be able to present all this evidence before a jury. When you get to a bench trial, the district attorney's office only needed the judge to find him guilty of something so we could come before this board, which we've been trying to get to for months, to come before this board and explain he didn't do anything to Ms. Thornton. And for 11 months of his life, he's been there. To that extent, I filed a motion to reconsider sentence. The day after, I filed a motion for a new trial, a motion to reconsider sentence. I cannot file the notice of appeal until the judge rules on the motion to reconsider sentence. But we have the motion to reconsider sentence. The stamp copy is going to let you know he plans to appeal and clear his name on these 2 misdemeanor charges. We're asking this board to give him the same sentence that the judge gave him. You've been in jail 12 months, Mr. Goods, because this all happened November 10th of last year. He was arrested. You've been in jail 12 months. I'm going to give you 6 months on the first misdemeanor, 6 months on the second, and and you go down to the parole board and take your chances. So as I said, we're asking this board in our position paper, we asked this board to give him 9 months on everything with credit for time served. So this matter can be placed behind Ms. Gigi Thornton and Mr. Goods.
Thanks. All right. Anybody else has any questions?
I move for an executive session.
All right. Okay.
Burrow,
Yes.
Renata,
Yes.
Freeman.
Yes.
Oh my gosh. Okay, they're going into executive session. We would be here until 4 o'clock this afternoon trying to unpack everything that we just heard there. Anything from threesomes to felonies, pled down to misdemeanors, pled down to or taken down to parole violations, witnesses lying, multiple versions of different stories. This is like Maury Povich, Sally Jesse Raphael, Ricky Lake, Phil Donahue. I don't know. As the TCF turns. I don't know. Should we sit here and wait through the... Well, of course we're going to sit... look, we're so far into overtime at this point. What difference does it make? I had no idea this was going to happen. I don't know if this was the best or worst hearing we've ever had on TCF in the just over a year that this channel has been on. So, all right, listen. While we wait, I mean, again, we're so far into overtime. What difference does it make? So let's just palate cleanse a little bit, and let's oh my gosh, I don't even know where we're going. Let's go and check in on Judge Boyd, and then we'll come back to Louisiana and we'll find out how that concludes in just a moment. I'm left speechless. Okay, I'm sorry. I need a flow chart to keep up with what happened there.
That's great.
All right, we'll check in with Judge Boyd, then we'll head back to Louisiana.
All right.
TCF
So who's
mega
the prosecutor
overtime.
on Charlie Marquez
Galloway.
and his, I guess the PF case that's an assault case. Is that going to be a district court matter?
Yes, Judge. I reviewed all the cases myself. Yeah, the fiscal officer or someone else has social cases that I believe will have some additional investigation. I would like to conduct before they were.
All right, Ms. Ferguson. On Marquez, I need a plea deadline date in December, please.
Yes.
All right, your plea deadline date is going to be December 8th. At that time, you need to let the court know whether you've reached an agreement or not. If you have not reached an agreement, your next setting will be a jury trial. Do you understand?
Yes.
All right, thank you.
Judge, on the 8th, I have a seminar that morning.
Okay.
You just will need to know if we have an agreement.
Well, now let me do this. So you say your seminar
On
is.
the 8th and 9th.
Yeah.
I'll do.
All right, Norma, recall this for December 11th. Defense counsel said he has a seminar. All right, once you sign the reset form, you're excused.
Thank you very much.
You're welcome.
All right, we're hanging with Judge Boyd, the epic cliffhanger to that Louisiana case coming up. They're in executive session. We'll come back to it in just a moment. It's maybe the most anticipated or not anticipated moment in the history of TCF.
That was on page 3. Yes, thank you.
I don't know. Is Dan going to ask me to come back and never fill in again? I don't know. We'll find out. All right. Judge Boyd's got the next contestant coming on down. Let's see what happens here.
All right. Who is here on Go. All right, if you have your client come down, please. Hi, good morning.
We have a communications issue. This English is very limited. We need an Arabic translator, or you can take me off the case and appoint an attorney that is an Arabic speaker.
Attorney who's an Arabic speaker, who is it? All right, if you call Jaime Adape, please. All right, just have a seat and we'll see if we.
Jaime on there.
All right, thank you. Your excuse. All right, just have a seat.
All right. Folks, it's time. Let's head out to Louisiana. Let's find out how this, hold on. There we go. Let's head out to Louisiana and find out how this wraps up.
I think we go back in the regular session.
Second.
Yeah.
I don't see any, I think that concludes our business. I think we're prepared to vote, Mr. Byron.
All right, Mr. Good. Today, I'm going to vote to not revoke your probation. And I'm going to add a special condition that you complete anger management, batterers intervention, those type of programs once you're released, and that you have absolutely no contact with Shalane Thornton. Cannot go within a mile of.
Yes, sir.
Mr. Freeman.
Okay, I'm gonna concur, but stay away from the victim, okay?
Yes, sir.
First off, I think it's nothing but trouble for both of y'all. So y'all stay away from each other, and you spent a year in already, so my vote is also not to revoke.
Thank you, sir.
All right, Mr. Goods, this has been very complicated all the way around. You did plead to, no, you didn't, you were found guilty of criminal activity, I'll say that. But I don't find that Gigi's testimony at any point in this whole thing was incredible. So I do agree with my colleagues. You've been in jail a year, almost a year. So my vote is do not revoke. We'll issue you a reprimand and add the special conditions that Mr. Barra went over.
Thank you.
So,
Thank you.
Thank you to each board member for hearing us.
Wow. All right. Well, parole. That's if we're going to have a parole granted or not revoked, I guess. Probation not revoked, whatever. Then I guess that's the one to do it, right? Wow. Let me see if I can bring up a flow chart. I don't know. I'm gonna try and figure out what just happened. That was well over an hour. That was well worth going into overtime, in my opinion. I'm so glad you guys hung out with us today. That was something else. I don't know if that was the best or the worst hearing we've ever had on TCF, but we'll figure that out later on. For those of you that I think Lindsay and maybe a couple other, I don't know. We had people that had to dip out in the middle of that. I hope you come back and check out the epic conclusion of that. Okay. So that's going to wrap it up for TCF Live for a Tuesday. What a day it was today. And, well, here's the best news of all. In about 22 hours or so, a little over 22 hours, we'll be back here to do it all over again for TCF Live on a Wednesday as Michael Groff, that's me, filling in for Dan Soul, who is on vacation and I'm sure is right now pedal to the metal, working his way back to Phoenix, to the Phoenix area to make sure that he gets control of this thing once again, because clearly old Captain Smith here steered it right into the iceberg. But whatever. All right. Hope you enjoyed it, everybody. We'll be back here tomorrow morning, 10 a.m. East, 7 a.m. Pacific, 45 minutes early for channel members for the pre-show. Dan will be on the road. I'm not sure if he'll be able to do the pre-show tomorrow morning, but if he is, you can check him out there. Channel membership, just $2.99 a month. It's the greatest value in all of YouTube. Take that, Mr. Beast. And join us then. Sidebar, we do not have Sidebar tonight. Sidebar will be back on Thursday night at 8 p.m. East, 5 p.m. Pacific. And if you want to see more of me for whatever reason, if you didn't get enough of me eating pizza during that and just settling on in, I wish I had popcorn for that. We needed popcorn for that hearing. Then if you want to see more of me there, check me out over on YouTube on the Phoenix, Arizona Weather Discussion, my channel, Michael Groff. I actually have multiple channels, but that's the one where I do daily weather videos for Phoenix and Arizona. It's great content, so do check that out. And no Maury Povich, Ricky Lake, Phil Donahue, Jerry Springer type stuff. I feel like I should leave my final... Here's my final thought. All of those people, by the way, I think that board, the parole board, should have given all of those people an edict to stay... He's like, don't go within a mile of her. No, none of those people should be within a mile of each other. They should all be wearing magnets to repel one from the other. That would be the solution for that. All right. Thank you so much again for joining me, everybody. Thanks to everybody in the chat. Barbara, Wahoo, and Ashley for donating super chats, super stickers. Oh, and Mama Joan, Grandma TCF, for your super chat, super stickers, and your channel memberships. That really supports the channel, and all that stuff supports me while I'm filling in for Dan as well. All right, goodbye, everybody. See you tomorrow morning.